Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's start our day with Judge Dad.
You posted $213 on July 17th.
Yeah, I got pulled over originally in November for.
I know. So you posted a bond because I issued a warrant for your arrest because you didn't bother showing up.
I'm sorry. It slipped my mind. My son was also born that month, so it slipped my mind. So when the state cop let me know that I owed the money, I just paid it to him.
All right, I'm just going to apply the bond to payment of fines and costs. Do you have anything else? So we're just going to apply that bond to payment of fines and costs, and you're all set. It's in your name. Good luck.
I appreciate it. Do I keep this?
Next time, show up. You would have saved yourself a lot of money.
I learned my lesson.
All right, good. I have a good day. Julian Angelo Johnson. 25 W839 115. Your name?
Julian Johnson.
All right. You're going to plead responsible to impeding traffic, right?
Yes.
You got to be careful. Your record is not looking good. You know that, right?
Yes, Your Honor.
Okay. To the charge impeding traffic, responsible or not responsible?
Yes, Your Honor.
Responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the fare to yield. 220 is your total. You can go down the hall and take care of that. Good luck.
Okay, thank you, Your Honor.
Don Denise Sager. 25 T645 899. Do I have any other show causes that might be ready? Or do you have anything else like show causes or anything besides this? Your name, ma'am? All right. Good morning. You're going to plead to impeding traffic, right? Okay. To that charge, how do you plead responsible or not responsible? Okay, I'm going to accept your plea. 150 is your total. Cash you into the hall. You're all set. Good luck. Original charge dismissed. Thank you. Daniel Harris. Daniel J. Harris, 25 T645 893. Good morning, sir. Your name?
Daniel Harris.
All right. So you met with the department rep, right?
Yes.
And you are going to tender a plea of responsibility to impeding traffic, correct?
Yes, sir.
All right. To that charge, you plead responsible or not responsible?
Responsible.
You accept your plea, dismiss the speeding. 150 is your total. Cash you into the hall to your right. Good luck. Paul Anthony Bruck, 25 T645 776. Good morning. Your name?
All right.
Good to see a smiling face up here. All right, that doesn't happen a lot. You're going to plead to impeding traffic, right?
Yeah.
Responsible or not responsible to that?
Responsible.
Please accepted, speeds dismissed, 150. You're all set. Into the hall to your right, okay?
Okay.
Good luck. Slow down a little, though. Godlewski. Rosemary Godlewski. 25B148896. Good morning, ma'am.
Good morning.
All right, so you met with him. You're going to plead to impeding traffic with the improper turn causing an accident to be dismissed, right? To that charge, impeding traffic, responsible or not responsible?
Responsible.
All right, just be careful, okay? I'll accept your plea, dismiss the original charge, 195. Okay?
Thank you, sir.
Good luck. Nathan Aaron Kelvis. 25B148953. Your name?
Nathan Calvis.
All right. Same thing with you. You're going to plead to impeding traffic, true?
Yes.
Responsible or not responsible to that? Original charge is dismissed.
Judge?
Yeah.
He has two cases one with Trenton, one with Brownstown. Not sure if he saw both.
I haven't seen both yet.
Okay, so this was Brownstown, so you have to go to Trenton.
Yes.
Go down 195.
Thank you.
Okay, is the other one in front of me, Lisa?
It's not yet.
Yes.
Seen the department,
No,
right?
I know, but that's assigned to me too. Is,
Yes, it is.
okay, lucky you.
Yeah.
Just kidding. Okay. People against Bogar, Timothy Joseph Bogar. 25F 244278. Sir, you're free to have a seat there if you'd like, if that's easier.
Well, just once I get up there, I'll be okay.
Okay. How you doing?
Pretty good.
Good. Okay, your name? All right, and you are going to, you met with the department rep, you're going to plead to impeding traffic, right?
Yes.
All right, responsible or not responsible to that?
Responsible.
Yeah, all right, 155, cashier rented the hall to your right.
Okay, thank you.
Good luck. Original charge dismissed. Are they getting backed up down there? Should I slow down a little?
Did you already do this one, Jen?
Yeah, that's from yesterday.
Okay, so it's just
I
gotta
don't
be
know.
Jennifer.
Right. All right, people against Edwin Lamont Rogers. 25F 244279. Good morning, your name?
Edwin Rogers.
All right, you're going to plead to impeding traffic, right?
Yes,
All right, to that charge, responsible or not responsible?
responsible.
Please accept the original charge dismissed 165. Cash your rented the hall to your right, and you're all set.
I got more time to pay it.
I'm sorry?
I have time to pay it.
Yeah, you need time? How much do you have today? You have any? Okay, tell me when you can pay this.
Friday.
Yeah, I'll tell you what, I'll just give you till Monday, which is the 28th, okay?
Okay.
All right, best of luck. Emily, Juliana Baracco, 25W838908. Your name? So you're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that?
Responsible.
Okay, and accept your plea.
Am I also able to get more time to pay it?
Sure,
Next Friday I get paid, so next week would be,
no problem.
thank you.
I'm going to charge you $150 and your due date is August. Wait a minute, let me think here. Yeah, August the 4th, okay? Good luck. Thanks. Good morning, Lieutenant.
Morning, Your Honor.
Tommy Dwayne Sadler. 25E148809. Morning, sir. Your name?
Tommy, when you said one?
All right, so you're going to plead to impeding, right? Is that right? No accident, right?
No,
To the charge impeding, responsible or not responsible?
responsible.
I'll accept the plea, dismiss the failure to yield. 160 is your total, okay?
All right, thank you.
I wish you well.
Thank you.
Jerry's Ehab Kildani. 25B148588. Good morning, sir. Your name?
Jerry Scrivener.
All right. All right. You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible to that?
Possible.
All right, I'll accept the plea. The default judgment is set aside. I'll accept the plea. Your total here is $175. You can go down the hall and sign over your bond. Just go talk to them. You're all set then, okay? Best of luck.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Tuesday. I hope you're all having an all right week so far. I know we are here at the bunker. I have something new for you this morning. This is the river that we've been watching up in Alaska with our bear friends, but this is a different view of it. This is called the Rifles, and it's about 100 yards downstream from where we've been watching the bears before. So we'll keep an eye on that today. Supposedly, from what the write-up says, this is where the mama bears like to hang out. So we'll, like I said, we'll keep an eye on that. Let's change things up and go down to Florida. Wade Mercer is doing his first appearances.
For first appearance, your mother is in the courtroom, Mr. Lovett. You've been accused of one count of aggravated assault with a deadly weapon. Mr. Mitchell, I need y'all to step outside. If I can't record if I can't hear, so y'all can step outside somewhere. Sorry about that. Mr. Lovett, you're accused of one count of aggravated assault with a deadly weapon. Mr. Lovett, there is probable cause for that charge. It appears you're already on probation out of Okaloosa County. Mr. Lovett, I'm going to listen to the attorneys and then I'll make a decision on bond or release status. Mr. McDaniel, anything?
Your Honor, we just asked for a reasonable bond.
Mr. Mitchell?
Judge, we just
Sorry,
asked,
Mr. Gill, I apologize.
we'd ask for a reasonable bond, that there be no contact with the alleged victim.
Mr. Lovett, since you're on probation out of Okaloosa County, I'm going to hold you 10 days with no bond, which is what I do anytime there's probable cause for a new charge and someone's already on probation. So even though I'm about to set you a bond in Jackson County, don't try to post it because you will not be released until we see what Okaloosa County wants to do. During that 10 days, I'm going to ask Mr. Gill's office to notify that county. If they want to seek a warrant, I don't know if a judge will sign one or not for VOP, but if they don't have one within 10 days, I'm going to release that hold. You would then be free to post the bond set in Jackson County if that's the case. So you've got a bond in Jackson County of $10,000 cash or surety with a condition no contact with the alleged victim. But you've got no bond for 10 days out of Okaloosa County until we see what their position is on whether or not there's a VOP warrant coming. Mr. Lovett, do you have any questions, sir?
Yes, sir. I do have a question.
Okay.
Your Honor, I'm being respectful as it can be. I want to know. I really want to know. Like, I don't know how to.
Are you asking?
Mr. Gelly's on probation in Okaloosa County 20-2867, 2869, 2870 CF. All of them are CF cases. 3 different case numbers.
2869, 28.
2867, 2869, 2870.
Thank you.
Yes, sir.
No questions, Your Honor.
All right, thank you. Next case is Lachey Thomas. Ms. Thomas, good morning. Ms. Thomas, you're here because you've been accused of one count of misdemeanor battery. Ms. Thomas, I've read the complaint in your case. I have concerns about probable cause. So I notified the attorneys this morning about those concerns. Let's see what their position is. Mr. Gill, the state like to be heard on probable cause?
Was it on Godwin or Ms. Thomas, Judge?
Both. There's a text on both. I'll read the only portion of the complaint that references you committing a crime is the following. Officer then spoke with Renee Thomas Gaines, who stated her daughter, Lachey Thomas, walked from the west side of the hotel to the east side and became involved in a verbal altercation that escalated into a physical fight with her. While engaged in this fight, Gaines' other daughter, and goes on to someone else attempting to intervene, and talks about some injuries. So the allegations are that you became involved in a verbal altercation that escalated into a physical fight. That's the allegation. Mr. Gill, anything from the state?
Judge, we would just submit that there is alleged video surveillance of this incident, which could give us more details as to what occurred. It sounds like there was multiple parties involved, and that at a minimum, she could be charged with an affray. So with that, we'd submit that there is probable cause. We'd ask for a reasonable bond.
All right, Mr. McDaniel.
It's against her mother, and it was very vague. I mean, the whole complaint was kind of, vague. We would just ask for some kind of, ROR or some kind of release option. If the state wants to go forward with it, they can clearly still go forward with it. But I didn't see a whole lot in there.
Yeah, Ms. Thomas, the summary of the video doesn't mention you at all. And battery has specific elements set forth by Florida law, none of which are in the complaint. That's no probable cause for a crime here. Even if you did, and I'm using their language, become involved in a verbal altercation that escalated into a physical fight with her, that does not include the elements of battery, unlawful knowing and touching, or knowingly touching another person without their consent. So it's not even enough for battery, period. Now, Mr. Gill is correct. There may be probable cause for another crime, but that's not what you're charged with. You're charged with battery. There's no probable cause. I'm going to direct that you be released at this time. That the law enforcement may be able to fix this. They very well may. If they do their job thoroughly and correctly, it could be fixed, possibly. But this is not sufficient. It's not a close call in my mind. That's not battery. So you're going to be released this morning, ma'am. Make sure the clerk's office has a good address for you. If your address changes, that way they can notify you of any court date if the state decides to try to go forward. Ms. Thomas, any questions?
No, sir. Well,
Mr. Gill, please notify the arresting officer of the issues. That's the second one of those I've seen in the last couple of months. So maybe a different agency, but that's not battery. Getting involved in a fight, it's not battery. Arguably, somebody's acting in self-defense in most cases.
Sure, Judge.
Anthony Godwin, Mr. Godwin, come on up. Mr. Godwin, you're here because you've been charged with one count of ag assault with a deadly weapon. I had similar probable cause concerns in your case for different reasons. I emailed the attorneys or texted the attorneys this morning. So I'm going to ask for their thoughts on that. Mr. Gill, what's the state's position on probable cause in Mr. Godwin's case?
Judge, the state submit that there is probable cause for an aggravated assault in this case. Again, officers respond to multiple individuals involved in something of a, physical disturbance. The video surveillance here shows that, at least from the report, that at one point, Godwin produces a machete from his waistband and begins advancing towards Lovett, the cross-complainant, who was just set a bond in this case. So there likely may be a stand your ground argument, but for PC purposes, Judge, the state submits that there is sufficient PC for an aggravated assault, and we would just be asking for a reasonable bond.
Mr. McDaniel?
I mean, I agree with, him, but there's clearly, self-defense issues here, I think that's quick, hang on. And clearly the officers just kind of took an approach of just arrest everybody. And I don't know. I mean, it doesn't seem like, there's a good self-defense there.
So I don't, it's a closer call than the last one. So here's the relevant language from the complaint. In the video, Lovett, which is another person, is seen running towards Godwin while holding a black and colored knife in his right hand. Lovett raises the knife above his shoulder and lunges toward Godwin. That's our defendant, Mr. Godwin. At that point, Godwin produces a machete from his waistband and begins advancing towards Lovett. So someone's coming at you with a knife, and the officer says you pull a machete out of your waistband and begin advancing towards them.
And, I think the
state's argument is that may be a stand your ground, but it's not related to probable cause for the crime of ag assault.
And Judge, go
ahead, Mr. Gill.
There's also this Alan Kenyon who was intervening. So at some point, maybe there's an intervening, and also he was struck by Mr. Godwin too. So with that, there could be an intervening. I mean, there could be a intervening incident here that separates the ag assault from the cross complainant to, Mr. Godwin being, again, engaging in an aggravated assault.
And I agree. The problem is could be is not what I have to deal with. I can't deal with what's could be. I got to deal with what they're accusing him of in the complaint. That's not probable cause. If I have a knife and I'm approaching you and you pull out a machete and come towards me, that's not ag assault. The problem is your criminal history is horrible. And when I find no probable cause, I have two choices. Number one is I can release the individual like I did with your other arrestee, Ms. Thomas, who had very little history. Or the second thing I can do is I can hold the person no more than 24 hours and give law enforcement an opportunity to fix the issue if they can. And if they can't, then you got to be released at that point. So what I'm going to do, because your history is so bad, Mr. Godwin, is I'm going to hold you 24 hours. I'm going to ask Mr. Gill to notify the arresting agency and officer of the problems. And if he can give probable cause for the crime, then I'll be glad to set you a bond tomorrow. If he can't, you're going to be released tomorrow. I will see you at tomorrow's first appearance, and we'll see if he can. Mr. Godwin, do you have any questions?
Okay. Yes, I never had no
Don't
mistake.
talk about your case.
Okay. Do you have a question? Any questions?
Yes. My question is, I've been out of trouble 10 years.
We've had a trial on you within the last year or so, Mr. Godwin. That's not accurate.
No questions, John.
Thank you. Christian?
Hi.
Ms. B, morning. You're here because you have a failure to appear warning, case 25-147 CT. The charge in that case is driving while license suspended or revoked knowingly. I'm appointing the public defender's office to represent you and asking that you listen to your attorney, Mr. McDaniel.
Your Honor, she has a preset bond of $2,500. She's going to try to post that bond. So just ask for it on the next arraignment document.
All right. Wish you the best, Ms. Beeman. We will put you on the next arraignment document. When will that be done?
August 25th.
So, Mr. Jailer, Corporal, if you give her notice for August 25th at 9 a.m., please, that'd be great.
That's my next court date.
Terrell? Yes. Terrell and Stacy Peterson. That's Terrell Peterson and Stacy Peterson. Gentlemen, your cases are identical for first appearance purposes. Both of you have holds out of Holmes County, and both warrants are violation probation warrants, and both warrants have no bond. So both of you will be held till you can get over to Holmes County and get these charges against you. Fellas, that may happen today. You may get over there today, and it may happen sometime later this week. But when you get there, you'll go to another first appearance in front of the Holmes County judge. But right now, you have no bond. Mr. Terrell Peterson, do you have any questions?
No, sir.
Wish you the best, sir. Mr. Stacy Peterson, any questions?
No, sir.
Wish you the best. Ken Snowden is next. Mr. Snowden, good morning. You're here because you have one charge of fleeing and looting, the second-degree felony variety of that charge, one count of reckless driving. I signed the warrant originally. I determined there was probable cause when I signed that warrant. I'm going to set you a bond. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell, Mr. Gill?
Just a reasonable bond, Your Honor.
Mr. Snowden, your second-degree felony bond on the fleeing and looting will be $10,000. The misdemeanor of reckless driving or criminal traffic bond will be $2,500. Your total bond is $12,500. Cash or surety. Mr. Snowden, cash or surety means you can go through a bondsman. You don't have to come up with all the money. You'll get used the phone in just a few minutes, sir, to try to post the bond. Do you have any questions? Wish you the best, sir. Gabriel Dominguez.
Yes, sir. Yes, Your Honor.
Mr. Dominguez, good morning. You have a holdout of Leon County, multiple charges over there, and the information we have from that sheriff's department is that at least one of the charges has no bond. So you're going to be held for them to pick you up. It should happen in the next few days. Any questions, sir?
That's all I needed to know. Thank you for informing me.
Yes, sir. Yes, sir. Wish you the best.
Thanks, sir.
Melissa Bonaventura. Ms. Bonaventura, good morning. You're here because you've been accused of one count of trespassing. Ma'am, I'm appointing the public defender's officer to represent you and asking that you listen to your attorney, Mr. McDaniel.
Give me just a second, Your Honor.
I didn't even see the back sheet. There's those. The ones we've done so far.
Your Honor, I spoke to Ms. Melissa, and she's going to plead of no contest to the charge of trespassing. The understanding should be sentenced to 10 days in county jail. She'll have 1 day jail credit. Just to let you know, I don't know if you saw it, but I think she has a Baker Act hearing that's going to be taking place on the 2 days from now in Bay County. So I don't know how that's gonna affect it. It's a Zoom hearing, so I'll let, maybe the jail can let her zoom into it.
Okay. Mr. Gill's that agreeable with the state?
It is, Your Honor.
Ms. Bonaventura, did you hear that agreement, ma'am?
Yeah, yeah,
Ma'am, is that the plea that you would like to enter to resolve this trespassing charge?
yes,
Ma'am, I'm going to accept your plea of no contest to the charge of trespassing and judge you guilty of that offense. Sentence you to 10 days in jail. Give you credit for time you've already served, which is 1 day. Mr. McDaniel, is that right?
Correct.
Impose the court costs and fines set by state and county law, which are $370. Ms. Bonaventura, ma'am, when you finish this sentence, you'll be released unless you have another hold, ma'am. I'm going to ask the jail to cooperate with the Bay County authorities to the extent they can so that you can make that court appearance by video if by no other way. If the judge down there wants her committed to a program, Corporal, please let me know because I may get input from the state. If they're not opposed to it, we may just let her go ahead and go and end the sentence if she's going to a lengthier program. So ma'am, we're going to do everything we can to try to get you that hearing, okay?
yep, thank you.
Have a good day.
Latoya Sheffield.
I'm sorry. Let's get Ms. Sheffield. Ms. Sheffield, good morning. Ms. Sheffield, you're here for first
Good
appearance,
morning.
accused of one count of criminal mischief, one count of resisting an officer without violence. Ms. Sheffield, there is probable cause for the resisting an officer without violence. The problem is there may not be probable cause for the criminal mischief for what you're accused of. Mr. Gill, anything from the state on the criminal mischief aspect?
Judge, it alleges that there was some damage, so we would just be asking for a misdemeanor bond on the criminal mischief.
Thank you. I agree. Florida law is very clear that if the officer doesn't put the amount of the damage in the complaint, the most I can find probable cause for is the minimum damage, which is nominal. So I'm finding probable cause for second-degree misdemeanor criminal mischief, not the felony criminal mischief the officer's accused you of. Mr. Gill, please notify the officer. I covered this in a training recently at that same agency, so it's a little
Yes, Your Honor.
confounding on how this continues to happen. I think it's happened twice in the last 2 weeks, but it's very clear in Florida law. The problem is you're already on probation out of Washington County. That probation officer's been notified of this arrest. Ms. Sheffield, I'm going to hold you 10 days. We're going to see if they're going to get a warrant or not. I'm setting your bond in Jackson County on the 2 misdemeanors. There is probable cause on resisting. If I didn't say that, the 2 misdemeanor bonds are $5,000 each because you're already on probation. So your bond in Jackson County is $10,000. Don't try to post it. So we'll see what happens with Washington. I'll see you in 10 days and we'll see if they have a warrant or not. Any questions,
Can I
Ms.
ask him
Sheffield?
some, I got a court date on the 28th of this month, and I was supposed to, I already did a violation, and he gave me another court date, because it's like a mail-in probation, so I was just supposed to pay the $900, if that helped, well,
Yeah, you're still technically on probation. This is a really
Yes.
unique case. You get off of probation in 2 days. I have no idea if the probation office and the judge in the other county are going to file a violation or not for this arrest. I don't know. The judge may
Okay.
say she's very close to getting off probation. We're going to go ahead and let her go, or the judge may say no, she's still on probation. So that's why I got to give them time to see what they're going to do. The court date you're
Yes,
talking
sir.
about is for a violation for financial reasons. It has nothing to do with this new arrest. Any other
Yes, sir.
questions?
Mm-mm.
Mr. Goodson?
No, sir.
I called Miss Maryland, the Washington County probation officer this morning, and she did want a copy of the complaint. She said she would be amending the affidavit, is what she told me this morning.
That's Mr. Goodson, Stacey Goodson with our probation office. Now, amending the affidavit doesn't mean that the judge is going to change the warrant status. That means she's going to add this to the violation. We'll see if the judge issues a new warrant or not, okay?
Okay. So 10
Have a good
days.
day.
All right, thank
So real quick, I want to cut in because I don't know if you caught it or not, but Judge Mercer explaining how he had recently done a training with law enforcement on the law they were talking about right there. I've never heard that from a judge in all of the hours that I have done where there's like this inner cooperation between law enforcement and the judiciary. So that was unique, that he was actually trying to train these people. Just thought I'd point that out.
So we have Mr. Deese, we have Bradley Johnson. Mr. Johnson, raise your hand, please. Is Bradley Johnson there? Okay, and then we have Olin Hunter. Mr. Hunter? Okay.
Yes, sir.
So Mr. Deese, Mr. Johnson, let's start with Mr. Deese. So Mr. McDaniel, I'm pulling it up in the system now. Did you get a chance to look and see if there's a VIP warrant for Mr. Deese?
Judge, I'm looking at it
Yes,
right now.
I think he's already been rained on it, but if they may have amended it, but it's case number 25-319-320. We're just gonna enter and we're gonna enter plea of not guilty and ask to settle on August 21st.
Mr. Dees, you do,
All the
Mr. Dees,
cases
you do
do
want an
have
attorney
court
appointed to represent you. Mr. Dees, you want an attorney appointed to represent you, correct?
Yes, sir.
I'm going to appoint the public attorney's office to represent you. What date, Mr. McDaniel?
August 21st.
Mr. Dees, any questions?
Yes, sir.
Mr. Gilly, anything from the state in that case?
No, Your Honor.
All right, wish you the best, Mr. Dees. Bradley Johnson, 24-256 CF. And is there a warrant I know there was a warrant. Was there a VOP affidavit filed in that case, Mr. Gill?
Judge, I'm showing that Judge Garcia warrant for violation of state probation.
Right. This one's really unusual because the warrant was issued before the affidavit. My question is, has the affidavit been filed so that I can arraign him? So, Mr. Johnson, give me a second. I talked to Judge Garcia about this when it happened. They have filed the affidavit of violation of probation now. So now that that's filed, I'm gonna go ahead and arraign you. Would you like to have an attorney appointed to represent you, Mr. Johnson?
Yes, sir.
I'm going to appoint the public attorney's office to represent you in this VOP case. Mr. McDaniel,
Yes, we're gonna enter plea of not guilty, August 21st, court docket, and Guy Green will come see him.
Mr. Johnson, any questions?
No, sir.
Wish you the best, sir. Olin Hunter, Mr. Hunter, good morning. You're in case 23-471 CF. You do have a no bond warrant that has been signed by Judge Garcia. I want to arraign you and get you appointed lawyer if you would like to have one. Do you want an attorney appointed to represent you, Mr. Hunter?
Yes, sir.
I'm going to appoint the public attorney's office to represent you. Listen to Mr. McDaniel, please.
Your Honor, we're gonna plead not guilty, as to set this on August 21st, and Mr. Green to come by and see Mr. Hunter.
That's what my lord.
August 21st, Mr. Gilly, anything that? Mr. Hunter, wish you the best, sir.
Yes, sir.
I think the last case we have is Alan Carroll. Mr. Carroll, looks like you got a new charge, a new felony driving while license suspended charge, and a 10-day hold out of Walton County. Mr. McDaniel, did you get a chance to look and see if there's a warrant out of Walton?
There is, Your Honor. It's violation of state probation, hold without bond.
Mr. Carroll, just advising you do have a no bond warrant out of that county now. I see the teletype from them. If you post bond here, you'll go to that county. If you don't post bond, you'll deal with our charges here first and then deal with them. Any questions, sir?
No, sir.
Wish you the best, sir. Mr. McDaniel, anything else on the first appearance docket?
Nothing else, Your Honor.
Corporal, anything else in the jail?
No, Your Honor.
And Mr. Gill, anything else from the state?
Nothing further from the state.
All right, ladies and gentlemen, that concludes first appearance.
All right, since he's wrapped up there, let's go to Texas. Say good morning to Judge West.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor. And I think we just go on counts 2 and 3 on this.
We do, we're not gonna go, we're gonna, draw allegations.
Okay, state's going to abandon 1. Will he waive the formal reading of that motion?
He will,
I just asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion to revoke your community supervision. Shows that you were placed on probation August 1st of 2022 for the offense of aggravated assault, family violence, and that was a 5-year term in prison that was probated for 8 years. Is that correct?
Yes.
It alleges in count 2 that you were at a location other than, that you violated your probation because you were at a location other than your residence at approximately 10:24 p.m. April 9th of 2025. And is that true or not true?
It's true.
And then count 3 alleges that you are behind in your court assessed fees. Is that true or not true? And what is the status of that offense from count 1?
I believe it's been refused.
Judge, it was refused by our office.
Okay.
So, and the remaining witnesses, it's the same as this one, but therefore we refused, we're not gonna go forward with the allegation.
Okay. Is there a no contact order in the probation
No,
though?
they're married.
They're married, Judge, and it's, I know the optics of it is bad for the kind of offenses that he's on probation for.
Y'all hold it down just a little bit. Go speak.
It looks bad for the kind of case that he's on probation for, but the complaining witness has come to my office, I've spoken with her, I think
We followed up with the judge, if we had it to move forward with.
Okay, I just wanted to check. All right. Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation and order 60-day jail sanction. And it looks like you've got 44 days credit. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. McKinley is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order a 60-day jail sanction as a condition for that. These allegations, you will get credit for 44 days. Here's the thing, something's going on, okay? And even at this point, if I think something's going on, the proof that is required for me to revoke your probation is not the same as is required if we go to a jury. And if there's anything that happens again, whatever's going on between you and her, if y'all are not good together, then don't be together because you're going to end up in prison. The offense that you're on probation for is obviously very serious. You've already agreed, when you got this probation, you already agreed to that 5-year sentence in prison. You violate your probation in any way again, you've got the 5 years. I don't care if it's having to do with her, if it's being out past curfew, if it's not showing up for appointment, this is it. So whatever's going on, y'all need to get whatever help you need. If it needs to be separated, then you need to be separated. Otherwise, you might end up in prison. So you have to figure out what's really best, to be in a volatile relationship in front of your children or to be in prison. You understand?
I understand.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. As soon as you're released from jail, first thing you do, report back to probation, get going on everything like you're supposed to. All right, good luck to you. Okay, did they get,
Mr. Jackson, I don't think it's been printed yet.
Miss Leonard, y'all have Miss Leonard? Come on up, Miss Leonard. Janisha Leonard, 3 cases are called. All right, you're Janisha Leonard. And Miss Leonard, in cause numbers 19-333-40 and 20-36095, on probation for theft of property and theft of service. And a motion to revoke has been filed in each of those cases. There's a new offense indicted 250297 with the allegation of theft of property. And so that theft new allegation is from offense date of August of 2023. And so obviously that was some time ago. There's a motion, let me get to the right paperwork. In each of these cases, obviously alleging that new offense. Mr. Rojas has filed motion in each of those motion to revoke probation cases that I set a bond, that currently they do not have a bond. Those are deferred, correct? Are they both deferred? Let me double check.
I think they're straight probations.
They're straight probations? Okay. So Ms. Leonard isn't necessarily entitled to a bond as if it were a deferred, but we're here to talk about that. Mr. Coleman has filed a state's reply to that motion. I have read and reviewed that and obviously understand Mr. Coleman's position. Mr. Rojas, you may go forward.
Call Ms. Leonard, John.
Ms. Leonard, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay.
Okay, Ms. Leonard, how long have you been in jail now?
14 weeks.
And it's my understanding that you've got a newborn baby at home. How old is that child?
3 months.
All right, and there's a little, you're having, or before you come in, you're having issues with breastfeeding or with feeding child?
Yes, ma'am.
Tell the judge about how it's.
My daughter's been breastfed since she was hospitalized at 3 weeks old. She also has a heart murmur. And since I've been in here, they've had trouble with her latching on to a bottle.
So let me ask, it looks like in these motions, the primary allegation obviously is that new offense. And then there is some community service hours and then very behind in fees and fines. Other than those things, I've got probation here. And if you'll just state your name for the record, ma'am.
Linda Core.
And is there, other than those items, is there any other issues that you are having with Ms. Leonard that I need to be aware of?
No, Your Honor.
Okay. If this new allegation was more recent, I'm not sure what happened with the timeline on this, and doesn't, for this purpose, I guess, doesn't really matter. But because it's been so long, and it looks like other than some fees and community service, everything else has been going well, I'm going to grant the motion to set bond in cause numbers 19-33340 and 20-36095. I'm going to set the bonds in each of those cases at $5,000 in each case. And obviously, if you make those bonds, the first thing you do is report to probation and do everything you're supposed to be doing while you're on probation. Yes, ma'am.
Is that included with the $10,000 bond with the new charge?
You have 3 different bonds. You've got a 10,000 and 2 5,000s. And so you need to get busy, because while this is pending, obviously would be, I would think, in your benefit to try to get some community service hours done, to get a job, start making some payments, show me and probation and the district attorney that you're trying, because just me setting bonds doesn't mean that you're out of trouble for this. You can still go to the state jail prison. So it's very important that you do everything that you're supposed to while you're on the probation, okay?
Yes, ma'am.
All right, we'll see y'all back at an announcement. We'll worry about that later. Yeah, I can't imagine that's going to be. Oh, I'm not going to do, okay, I don't need that. That's all right now. Got it. Hallie Rolls, Mr. Rojas. And then we'll take a break, and I'm going to have to do a hearing with Mr. Burbank. Mr. Burbank, I'll take care of your case next. We'll get started as soon as I'm done with this. Is this for both or one?
One's a motion to revoke.
Oh, okay. This is,
Oh, did I put the wrong number on?
no, you just didn't finish. That's all right. Okay, so let me go. Are you Hallie Rawls? Will your client waive the formal reading of the indictment and the motion?
She will, Your Honor.
Ms. Rawls, in cause number 25 DCCR 0623, let me pull up the wrong one. You're charged with the 3rd-degree felony offense of possession of a controlled substance from May 30th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Rawls is not competent?
No, Your Honor.
All right, ma'am, and cause number 250623, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 241987, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation January 27th, 2025 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed February 13th, 20th, March 6th, 20th, and April 8th of 2025. And is that true or not true? True. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you did not provide verification of performing the community service as required. Is that true or not true? Count 4 alleges that you did not provide verification of completing the theft prevention class. Is that true or not true? Count 5 alleges you're behind in your court assessed fees. Is that true or not true? And then count 6 alleges that you failed to complete a mental health evaluation. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have some documents in that case here on the computer that have your signature on them that the state's marked as exhibit number 1. Did you also sign and go over these with Mr. Rojas? And do you fully understand them? State tenders number 1.
No objection.
It's admitted. I'm going to find, Ms. Rawls, that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find that those counts true, again, that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These sentences will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. That's okay. I caught him. Quick reflexes. Hold on just a second.
Alrighty, let's change it up. Michael, get your vote in. Let's go to Louisiana.
Committee on Parole to order. We're in Baton Rouge, Louisiana, at the Department of Corrections, the headquarters. The time is 8:44 and the date is 7/22 of 2025. On my left is Chuck Tillis and on my right is Carolyn Stapleton. And my name is Steve Prater, and we'll be the three that'll be running the show for today. The first place that we're going to be going to is going to be to Calcasieu Correctional Center, and we'll be seeing Joseph L. Hagan. before we get to there, I'd like the staff to introduce themselves.
Jasmine Thompson. Sure.
Okay, thank you. Appreciate the work that y'all each do. We'll be talking about a case with Mr. Joseph Hagan that is assigned to Miss Carolyn Stapleton today. And so we'll go ahead and get started. Mr. Hagan, is that you there I'm looking at?
Yes, sir.
Okay, what's your DOC number?
715613.
Okay, and you're in for a revocation hearing, is that correct?
Yes, sir.
Okay, you at Calcasieu, is anybody in the room with you? Any staff member in the room with you?
No, sir. He's outside the door.
Okay, that's fine. Now, the revocation hearing is going to be conducted by Ms. Stapleton. She's going to be the one that's going to go over your rule violations, but do you have a waiver in front of you anywhere? I don't see it on the table, but you should have signed a waiver about the hearing today. It deals with your attorney and things. We can show it to you on the screen.
Yes, sir. He's got it outside.
Okay, he's got it outside and you signed that willingly and you understood everything on that waiver, correct?
Yes, sir.
Okay. All right. Well, I'm gonna go ahead and turn the case over to Ms. Hagan. Excuse me, Ms. Stapleton. Mr. Hagan, there's your form. And Ms. Stapleton, both violation that you're accused of or violations, and give you a chance to plead to those in front of us and to talk about them. And she'll ask any questions. And then Mr. Tillis and I will come back in a minute and ask you any questions that we have. And then we'll make a decision, decide whether you should be revoked or not. Okay?
Yes, sir.
All right, Ms. Stapleton, would you go ahead and get started for us?
Okay, Mr. Hagan, we're going to start with what you were accused of, and you get to plead guilty or not guilty with a statement, okay?
Yes, ma'am.
Ready?
Yes, ma'am.
It is a rule violation number 4. You failed to refrain from criminal activity. You were arrested by the Westlake Police Department on 6/8/25 for aggravated battery and obstruction of justice. How do you plead guilty or not guilty?
Plead not guilty, ma'am.
Okay. All right. And then you have a violation number 10. It says you have failed to pay anything towards your supervision fees. You are in arrears of $882 for your supervision fees. Guilty or not guilty?
Yes, ma'am. Guilty.
Okay. Okay, why don't you tell me, now you pleaded not guilty on number 4. And
Yes.
probable cause was found for that. I'm gonna read to you what the probable cause was under section 3 of the hearing. It said, Agent DeVille alleged the subject violated his condition and that he failed to not engage in any criminal activity. This being evident from subjects arrested by Westlake Police Department on 6/8/25 aggravated battery and obstruction of justice. Agent DeVille provided a police report which highlighted these charges as well as photos of the victim's injuries. According to the police report, officers made contact with the victim who was bleeding profusely from the face. The police report indicated subject punched the victim in the face with a closed fist. However, further investigation reveals subject also used a metal door to hit the victim before leaving the scene. The report states the altercation began over the subject taking property from the subject 2 days prior. Officers were able to make contact with the subject initially, however, were called back to the resident by the homeowner who advised the subject was hiding in a shed in the backyard. Officers located the subject, placed him in handcuffs, and advised him of his Miranda rights and then transported him to the Calcasieu Correctional Center. Officer Chandler provided a statement that upon arriving on the scene, he was giving the subject loud verbal command to exit the shed. However, he failed to comply. Chandler stated subject eventually came out from the shed and was placed in handcuffs. Chandler stated there were multiple witnesses on the scene who identified the subject as the aggressor. The subject advised he was defending himself from the victim who was attempting to attack him with a knife. Subject denied hit the aggressor and hitting the victim with the door. Subject advised he has been consuming drugs and has a drug problem and he needs help. Subject was advised probable cause existed, that he violated his condition, and you already pled guilty to number 10. So there we go. That's where we're at right this very minute.
Ma'am.
Got a picture and there were witnesses that said you were the aggressor. And then you say that you have a drug problem.
Yes, ma'am.
So are you now willing to plead guilty to number 4?
Can you read it again, please? Number 4?
Yeah, you want me to read where, okay, I'm gonna read where, police provided a police report which highlighted these charges, as well as photos of the victim's injuries. According to the police report, officers made contact with the victim who was bleeding profusely from the face. The police report indicated subject you punched the victim in the face with a closed fist. However, further investigation revealed that the subject, you, also used a metal door to hit the victim before leaving the scene. The report says the altercation was over the victim taking property from the subject 2 days prior. Officers were able to make contact with the subject. Initially, they were called back to the resident by the homeowner who advised the subject was hiding in the shed in the backyard. You were arrested. So that's the crime, and that's what you're accused of, and we do have the pictures, and the man went to the hospital.
Yes, ma'am. See, that guy came to my house and it was all over drugs.
Okay.
I didn't have no drugs. He wanted drugs. He got mad, said that I stole something from him, I guess to my mom and dad just to get in the backyard. I don't know, but I didn't steal nothing from the guy. It was all over drugs. Well, I do have a bad drug problem. I do need help. I just, I don't remember too much of it, but I remember the guy pulling the knife on my pregnant old lady. I had my old lady was in the background. She was big and pregnant. When he pulled that knife, I hit him. I punched him. Yes, I did. I admit to that.
Okay.
But there was no aggravated battery in it because I didn't have a weapon. All I did was hit the guy.
Well, when you hit him with your fist, and it was a closed fist, and then later it said the metal door, but your fist is an aggravated battery.
The metal door was padlocked on there. The arresting officer can say that my dad actually went back there and ripped the door off. But it was
So you
all
just said you did hit him with your fist, right?
Ma'am?
Hit him with your fist.
Yes, ma'am. I did hit him.
All right. So where are we at? Would you want to stay there and then us recommend, or myself recommend, that you go to a drug treatment program while you're there? Get some help?
Yes,
That's
ma'am.
not bad.
I do need some help. I just had a little girl, and
Yes.
I don't want to go back out there being the same. I was about to cuss. It was the same mess up that I've been my whole life.
Right.
And yes, ma'am, I really do need help.
Okay, and that's a good thing. And we can do that. You can stay in there, and we can recommend that you go to a long-term treatment plan, and then you get the help that you needed. And they've got 2 very good treatment plans. So
Is one of them the Hope Center? Is one of them the Hope Center?
Well, no, Steve Hoyle. Have you ever heard of that? And then there's Blue Waters is another one. But Steve Hoyle is what I understand the best.
Where is that at?
Freeport. Bossier. It's in Bossier.
How long is the program?
I think the longest it is 9 months, and then there's a 6 months program too.
I would definitely go through it. What's the other one? Blue Waters, you said?
Yeah, I don't know the information on that. I just know that the Steve Hoyle is considered the best. So, I mean, we can recommend that. It's only a recommendation.
Yes, ma'am, because I talked to my lawyer. He said, man, if he could get the parole board to lift the hold, he said he'll get me in a program. He'll get me help.
Well, you still violated your parole. I mean, it's aggravated battery. You hit him with your fist. You violated your parole. You're in, whether you go somewhere or not.
Yes, ma'am. Well, y'all, what does revoke mean? What is that exactly?
Well, it means that you're gonna stay in jail now because you didn't stay on, your parole, yeah. So whatever your term was. How long did you have to serve on your original?
I've been dealing with this reentry stuff since 2019. I even went to Angola, finished the program, and I'm still on papers fighting this reentry. I don't know when am I going to be done with it, but it's hectic because I signed a contract stating I was going to go to Angola. I finished the program. I left with a trade. I couldn't even work because of the probation that they had me on. I constantly kept losing my job because of piss tests. I had to go pee in a cup every single week. My boss didn't understand that.
Well, welcome to the world of being
They said that I was going to take me on parole.
Here's where we're at, Mr. Hagan. You
Yes,
played,
ma'am.
so today I'm going to revoke you. That's
How
where we're at.
long do I have to do?
I don't know. You'll have to talk to somebody that does time because I don't know that information.
Okay, is that all the questions you have?
That's it.
Okay, Mr. Tillis, any questions? No. I don't have any questions. It's time to vote. Ms. Stapleton?
Mr. Hagan, today, I vote to revoke your parole based upon that you did violate number 4 and number 10.
Okay, we have a vote to revoke. Mr. Tillis?
My vote is also to revoke.
Okay, and likewise, my vote is the same. And our recommendation, along with our revocation is, and we're going to recommend that the Department of Corrections find a long-term drug program for you, and see if we can get you in that thing, which I'm sure they will try to and will. So, good luck with it. And I think that's very mature, you realizing that you got to stay in to get this help, because if you get out, temptation is too great. I think it's very mature of you. So as of today at 8:57 in the morning, you are hereby revoked and headed to a drug program soon, I hope. That's it.
Denied. And there you go, my friends. So let's check on our bear up in Katmai. Looks like we're having breakfast. So that's outstanding. Oh, there's a birdie. All sorts of fun up in Alaska right now. Let's go to Judge Simpson. Haven't been there yet this morning.
You want the 31st or the 7th since he's in custody?
I would take the 31st, Your Honor.
July 31st, 2025, 9 a.m. As to bond.
Thank you, Your Honor. My client's been in custody for over 30 days now. He had an outstanding warrant on a vehicle for a misdemeanor registration that's been resolved as a civil infraction at this point as of June 24th. He doesn't have any prior convictions for violent offenses. He had a strong work history of over 5 years as a manager at Los Amigos in Ann Arbor. He's most likely lost that employment now due to his detainment. His family needs his financial assistance. He has a very strong family relationship in the area. He's retained our office to represent him in this matter. Since he's been in custody, he's been enrolled in AA classes. He's working in the jail's kitchen. So we're asking that he be released on a bond. I would ask for a PR bond. I know the prosecutor's office in the proposed order I provided you, they would be requesting home confinement. I won't speak on her behalf, but that's something I know the prosecutor's office was asking for. If that's something that would persuade the court to allow him to be released, so be it. and any other conditions that the court would impose. If it was home confinement, we would just ask that he have the ability to travel for work purposes, school, medical appointments, etc.
Response.
Thank you, Your Honor. I did have a chance to speak with counsel as well and express my concerns on this case. As the court knows, the bond violation is the second case involving the OWI and some other issues. I don't have an issue with him being released to home confinement. I would request some form of alcohol testing, whether that's a sober link or scram tether, due to those circumstances and alcohol kind of being a theme throughout some of these cases.
So you're saying the drunk driving was a violation of his bond?
The case in its entirety was the violation. It occurred after his arraignment on the prior case.
That didn't answer my question.
I'm sorry, can you?
The 15th District Court case is the violation. For which one came first?
The 14D case came first, 25.
Thank you. That's what I need. All right. Anything else on this?
No, Your Honor.
All right. I will grant the release on this. I'll give him a $15,000 personal recognizance bond. Defendant, prior to release, will be placed on a home confinement tether, as well as, what was the alleged BAC in his drunk driving case?
Yeah.
She's not here today. That will be well, let me do it this way. The GPS tether will be a home confinement tether, and we don't know the BAC.
Unfortunately, Your Honor, can I pull this up?
We'll just put him on a sober link then. Testing device. All right. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case People versus Carlos South.
Andrew Banks for the people. Roberto on behalf of, but not with Carlos South. You understand that there is a violation. I have not been able to contact him. I do have a good number, but I've just not been able to reach him.
No.
Asking for a show cause at this time.
Well, he's showing up. The violation of court is he's showing up with cocaine now in his system. So a bench warrant will issue for defendant's failure to appear until we get him no bond.
Understood.
That will issue immediately.
Understood. What's the dollar amount, Your Honor?
Pardon?
What's the dollar amount?
No bond.
Oh, no bond. Oh, thank you. Understood.
So that would be a 0. Court does call the case Other People versus Robert Galit.
Hey, here, Richard McDuffie for the people on both nights.
Alex Warren Green on behalf of Ms. Gallant in the matter ending 5713.
Good morning, Your Honor. Jake Kilwall, Judge, I'm on 5612.
Robert Gallagher, also known as May.
Thank you. All right, what are we doing?
Judge, we're working on a possible resolution in this matter. We've spoken to my client. We're asking for a 2-week adjournment.
I would join that request, Your Honor. I'm completing the green sheet right now.
One of these doesn't have a green form, I think. Mr. Kilowog. Probable cause conference will be adjourned to July 31st. Will that be enough time for you guys to get done what you've done?
I believe so, Your Honor.
July 31st, 2025, 9 a.m. Bound continue.
Thanks, Judge.
Thank you, Your Honor.
Court calls case People versus Michael Ware, 2 cases.
Edward Lucas on behalf of Michael Ware.
Stephanie Cannon on behalf of Mr. Ware as well, Your Honor.
I'm an 863. And I just talked to him on the phone. I understand he's late. I'd be asking if the court could pass it.
And I would ask as well, Your Honor.
Where is he?
He said he was 10 minutes away, and that was about 5 minutes ago.
Call it up. Well, then, call it up in 5 minutes. We better be here. Now he's getting a warrant.
Thank you, Your Honor.
Court calls case Other People versus Tubbs.
For the people.
See, and I didn't call it like I normally call it.
Morning. Well, I'm the only one here on 1038. Judge, I was.
Your name, sir?
Oh, I'm sorry.
Shaquille Tubbs. Is that how you say it, really? Okay, all right.
Judge, I saw Shaquille last night at jail. I told him I had just been appointed. It's my understanding Ken Overwater is trying to get this young man into a recovery court with Judge Kuhnke. We're working on that. I explained to him I would be asking for a 2-week adjournment.
You said he's in recovery court, or they're trying to get him
It's
in?
my understanding he was initially denied several months ago. They're retrying him, so it's going to take a little bit of time.
Hearing no objection, I'll adjourn this to August 7th, 2025, 9 a.m. I'll continue. Thank you. Court calls case People versus Riel Boyd.
Ready, Your Honor.
Alexander on behalf of the people, Your Honor.
Jake Columbia, Ms. Riel Boyd.
Riel Boyd.
Judge, we're working on a resolution, possible resolution of this matter with the prosecutor. We're asking for a 2.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
And you got to give me that countdown there, 5.
Real quick, while he's between contestants, I just got notification, and I need to work on this because it looks like it's a little late. But ZT Rivera made a $5 donation on the website. Thank you for that so much. Very much appreciated.
Owens, can you please state your full name for the record? Devontae LaJuan Owens.
Thank you. All right. Sir, what are you asking for?
Respectfully requesting adjournment, Your Honor. I was just appointed yesterday.
Yesterday. Probable cause conference.
Sorry, I'll speak with Mr. Bird as well, but I have been speaking to the Sheriff's Department. I know there's been a lot of ongoing investigation that's still happening, as well as cell phone analysis. I know specifically with respect to Mr. Owen's phone, so I'll make sure that that stuff is shared as fast as possible.
All right. Do you think you'd be able to get enough of that information at least to council by the 31st, or do we need to go out one more week?
If we could go one more week, that would be my preference.
Any objection, council?
No objection, Your Honor.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continue. All right, thank you.
Thank you.
Yes, sir. Court does call the case of the People versus Theophilus Smith.
Ooh. Thank you. Judge Simpson, I can speak.
It's your case.
Yes, I can tell you what happened. I've been in jail for 100.
Hold on. Theophilus.
We're ready in this matter, Your Honor. I'm Brown, Deputy Chief Defender, appearing with and on behalf of Mr. Smith, who appears by Zoom. Mr. Smith, could you state your name for the record?
Theophilus D'Angelo Smith.
All right, you're requesting a forensic evaluation?
Yes, I think this matter is still,
No,
there's one
I can speak for my Lauren Brown. Please don't say that. Please don't say that. That's insult my intelligence. That's insult my intelligence. No, 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 no. You ain't even advocate with me. I will speak on my own behalf. And then you can
I
tell
believe
me.
there's one that's pending already, Your Honor.
Your Honor, the last update I have from May is that he was found incompetent but restorable, and
Right.
today was well, it had been scheduled on the 31st to check in.
No, come on, like,
And
come on.
so
Can I
has the
speak,
court,
please? Can I speak, please? Without
one moment,
my case?
one moment, please,
I can
Mrs.
easily, I don't want to have to do it, but just let me
already been
speak,
sent
please.
out for one.
You get a chance, but wait on just a minute so that we can make sure that what you say has meaning.
No.
Has the court received an
Every
updated?
word I speak, that mean I
I
said
have
something.
not. Mr. Smith, I'm not gonna try to talk over you.
Okay, go ahead.
I am not gonna try to talk over you. So if you want to keep doing that, then I'll just mute you. Have a seat. Let me. Okay. Or dance.
Please, no, I need to speak. I don't got time to be, I speak for myself.
Okay, Mr. Smith. You need to have a seat and don't interrupt me.
So, Your Honor, has the court received an updated report with respect to Mr. Smith?
I have not.
We have nothing further to present at this time. Would request that this matter be adjourned so that we can get an updated report.
And on the new case, requesting a forensic.
Yes.
All right. So on both of these matters, the one is set for a competency review.
Right, exactly right. The other is just tagging along with it.
So the new one, I'll set a competency. We don't have a new report, but one is coming in soon. So why don't you give me 45 days? Well, let's just give me the 90 and then I'll
October 23rd.
I'll adjourn this to October 23rd, 2025, 9 a.m. Mr. Smith, you're muted.
My life.
All right. Mr. Smith, what do you want to tell me? I'm going to give you 2 minutes to tell me what you want to tell me.
Me sleeping in the worst cell and radiation. Me can't lay down without men feasting over me when I wake up. I gotta pray hard. I gotta sing, and the Holy Ghost be in me. And they praying over me. They beat me. I'm just saying, an ends to a means. Like everything's been recorded. Everybody know everything. Simpson, please, Simpson, do America a great justice. Injustice anywhere is a threat to justice everywhere. Please,
okay.
I can tell you more. I can tell you names. I'm tired. I'm scared to tell everything while I'm in here. My family is scared for me life. No, just do the right thing. I just ask you. I believe you are a judge that speaks justice. I believe you will just come on, just do the right thing. And my Lord, I trust. Amen.
I've done the right thing. We'll see you at the next hearing date. Okay. Thank you, Mr. Smith. You can mute it now. On continue. Court recalls the case of the People versus Michael Ware.
You're Richmond, this group of people.
Stephanie Cannon on behalf of Mr. Ware as it relates to case number ending in 5134.
On behalf of Michael Ware.
Here?
He said he was in the parking lot here.
He said he's in the parking lot?
And so I'm looking.
Told me 10 minutes before.
I know.
We needed 13.
What?
We needed 13
13 what?
minutes. Right.
I have a progress report. I don't have a bond violation.
Yes, Your Honor, I have a progress report. I don't have a bond violation.
You guys are gonna try to stall? Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. That warrant will issue immediately. They need to be here.
And Your Honor.
Sounds good.
Your Honor, what was the bench warrant? Again, 10,000 cash shorted?
Yes, ma'am.
Thank you.
Okay. Court calls case people versus Haruska Dennis.
On behalf of the people. Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Haruska Dennis, and I'm appearing in case number ending in 1150.
Public defenders, not appearing. Your Honor, on the other matter, representatives.
All right, what are we doing?
Your Honor, this is a date and time set for a PCC in this matter. We did receive a mitigation report, I believe, just a couple days ago that was just very recently submitted to the prosecution. Given that, we would ask for an additional PCC to have time to complete those negotiations.
And that's our request on our matter as well, Your Honor.
On 31st of the 7th.
Judge, I would ask for the 31st, given he's in custody.
Yes.
Second.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bonds will continue.
Okay, you're awesome. Thank you, Judge.
Court calls the case for the people versus Tanya Hall.
Morning, Jake Columbia from Ms. Hall. Tanya, are you here? Judge, as you know, Ms. Hall is homeless. She's been staying at the Delana Center. I went there. They would not tell me. They could not confirm she's there, but I know she's there. I left a note. I never did speak with her. Would the court be gracious enough to give me one more adjournment to find her? Apparently I left a note. Apparently she
I have
came.
a cocaine test. A test positive for cocaine, and then she missed. So I might under the circumstances, but I'm not going to at this point. I'm going to issue a bench warrant for failure to appear. Bond is setting amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you. Court does call the case people versus Mario Crawford.
Andrew Dennis.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Mr. Crawford. Can you please state your name for the record?
Mario Crawford, Your Honor. Thank you.
Your Honor, we'd respectfully requesting an adjournment. We believe we are close to a deal with the people, and we would just need a little bit more time.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case people versus, is it Chantel Bray Page?
Thank you, for the people.
And greetings, Your Honor. Emmett Greenwood on behalf of the defendant. My client is in person.
Your name, sir?
Chantel Burpage.
All right.
Yes, Your Honor. Prosecution has graciously provided me all the discovery, so we're respectfully asking that we have an in-person exam.
Later, we have the fifth. Is that correct?
Yes.
Discovery being complete, would people have their witnesses available? 12 days, that would be the day. August 5th.
Let's try our best.
Preliminary examination, August 5th, 2025, 9 a.m. That is in person before Judge Freshour.
Okay, nice. What date was that again, Your Honor?
August 5th.
Yeah, that's no problem. And Your Honor, may I address Bond very briefly?
Very briefly.
Yes. My client has requested that he either stop having a drop or at least reduce the amount of drops. He hasn't tested positive or anything. but it's creating such a financial drain on him and his family that he doesn't know how he'll be able to complete all that.
What is his current schedule?
Every week, at random.
Every week?
I just got a call every day and
Well, given what appears to be the drug in here and his drug of choice, weekly testing is an appropriate testing.
Would you
So
consider
motion
bi-weekly? Would you consider bi-weekly?
I will not. You can bring it up before Judge Freshour after the exam.
and I got a court date on the 5th too in Canton. I think it's at
So
9
you can't
o'clock.
do the 5th?
I would have to adjust it with them. This is more serious than the other stuff, so.
Pardon?
I said this court date is more serious than the other court date, so.
Well, Your Honor, if he has a conflict, maybe we can do another date. Because we're ready to go.
Would the people be ready on the 29th, a week from today?
I doubt it, Your Honor.
And the next date I have would be the 12th.
That's fine for defense.
August 12th, 2025, 9 a.m. It is also before Judge Freshour.
All right, in person. Thank you so
Yes,
much. You all
All
take
right.
care.
Thank you. Court does call the cases of the people versus Matthew Fonseca.
And Alex Warren Green on behalf of Mr. Fonseca. Mr. Fonseca, could you state your name for the court?
Matthew Lewis Fonseca.
Your Honor, today's date and time for probable cause conference. At this time, we're asking the court to adjourn these matters so that I can continue my negotiations with the people.
Probable cause conference, without objection, July 31st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Deja Moore.
Christina Costantino appearing on behalf of Ms. Moore, who appears via Zoom. Ms. Moore, can you unmute, turn your camera on, and state your name for the court?
Deja Moore.
Thank you.
Judge, this is the date and time set for PCC. I believe discovery is complete, so we would be asking to have this matter set for an in-person preliminary examination.
People have their witnesses available the 5th.
Judge, I apologize. I have.
No, you don't.
I haven't.
No, you do, but you don't mean.
I do, but.
The 12th or the 29th?
The 12th would work wonderfully. Thank you, Judge.
Not a problem. Preliminary examination will be in person, August 12th, 2025, 9 a.m. That is before Judge Valwell. Bond will continue.
Thank you, Judge.
Thank you.
All right, let's change things up a little bit. Let's go back to Texas and Judge Boyd.
All right, we'll start again. So the court is finding that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments without objection. The court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Oh, yeah.
All right, the court will follow your agreement, sentence you to 30 years in the prison. There's an affirmative finding of deadly weapon, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so what date do you all want to bring this back for victim impact?
Judge, at this point, the state would be requesting July 29th, which is 1 week from today, to allocate for the victims.
That works for me, Judge.
All right, if you'll put a hold on him, please, for July 29th. We can go off the record. Sir, here's the thing. 30 years is a lot of time. And with you, you're going to have to do half the time before you're even eligible for parole. While you're there, you need to make some changes in your life. If you don't, what's going to end up happening is at some point you're going to be released, right? Either you're going to end up serving the full 30 years, and if you serve the full 30 years, you'll still have more life ahead of you. The person that was killed, they have no more life ahead of them. You understand? So while you're doing your time, sit and think about what you've done wrong in your life and how you can change things to be a better person. You understand?
Yes, ma'am.
All right. Good luck to you. We'll bring you back on the 29th.
Thank you, Judge.
You're welcome. Yeah.
Let's stay in Texas, but let's go back to Judge West.
You can work on, you can get that taken care of before. All right, are you Cody Dent?
Yes, ma'am.
And Mr. Dent has two motion to revoke probations and cause numbers 13-17772 and 22-41052. And there's a new offense, a burglary of a building, in cause number 250807. Mr. Samuel has filed a motion asking that I set a bond in those two MTRP cases. Is that correct?
Yes, Your Honor.
And let me get that pulled up.
As well as the motion for access to mental health expert.
That I probably don't even need to have a hearing. If you've filed the motion and there's,
Yes.
I'll look at it once if you'll just get it all filed with that attached to it. It needs to be e-filed. I'll take a look at it. It's no problem typically, as long as you have that affidavit of indigence attached.
Yes.
Okay, so. Oh, here it is. So are there no bonds set at the time?
Correct.
Okay, and are they deferred?
Yes.
They are both deferred. Mr. Smith, what is the state's position with regard to bonds?
I show on F-22-4105-2, it's a straight probation, 2 years, suspended for a period of 5 years.
Which one?
The second one, which would make sense if he got on probation after he was already on probation. Give me just a second. I want to take a look at the PC and that new offense, and then I'll let you put on any testimony you need. All right, I'm printing something. Do you wish to call a witness, Mr. Samuel?
Yes, I call Mr. Dent.
And you need to speak up so the court reporter can hear you, please.
Mr. Dent.
Mr. Dent, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. Go ahead, Mr. Samuel.
Yes, Mr. Dent, you were placed on probation initially in 2015, is that correct?
Yes, sir.
Okay, and since that time, you had one other charge that came up, is that correct?
Yes, sir.
Okay. Right now, are you presently under the care of any doctor facility?
It's been a time.
And are you presently on medications at this time?
Yes, sir.
Okay, and what medications are you?
Ooh. Don't make me lie, I don't know them by heart.
Okay, you live with, who do you live with?
My grandmother.
And you don't have any children, is that correct?
No, sir.
And your only source of income is from SSI?
Yes, sir.
Okay, and with that, now, going to the date in which you were last arrested, that was, when it says burglary of a building, that was a container, is that correct, at a business?
Yeah, well, I thought it was a gypsy dumpster.
Okay, just answer the question that I asked you, please. Okay, it appeared to be a dumpster, is that correct?
Yes, sir.
You didn't think that was anything wrong with getting something, you thought it was trash, is that correct?
Yes, sir.
Okay. At that time, had you had your medications?
No, I didn't take any medication.
Okay. Your Honor, we believe that, I passed the witness, Your Honor.
Any questions with regard to this hearing?
No questions regarding this.
All right, give me a second. I'm reading the pre-sentence report, the PC.
Yes,
So it
ma'am.
shows that this was, the allegation is from theft at Discount Tire.
Right,
And there was a shipping container,
right.
and he was allegedly removing tires and placing them in his vehicle.
Right.
And this, the business apparently was closed, signs on the container.
And we will show the container, the signs, they somewhat obscure, but they were
Well,
there.
but they're on the business
Right.
property with tires that belong to Discount Tire business.
Used, and the value of the tires were
Doesn't
$50
matter.
a piece. I
Okay.
understand.
I guess I just want to make sure the problem is if we're having, okay. So the first probation was for obstruction or retaliation placed on that probation 2015
Correct.
for 5 years. I'm assuming that has been extended. And then while on that probation, there was a theft of property, was continued on the first probation, placed on probation in February of 2023 for a 5-year straight probation. And now we've got this.
Correct.
Okay, I think at this time, based on the nature of the underlying offenses and based on the allegation in the new offense, based on the fact that there are some obvious mental issues, I don't know that it's in the best interest of anyone for me to let Mr. Dent back out to be doing the same thing. It sounds like he's stabilized. I want to make sure he is. We can get an evaluation done. We'll get you an expert, and then we'll set it for a hearing. But I'm not going to grant the motion setting a bond. I don't think that is in the best interest of our community or Mr. Dent for that matter.
Why can excuse me, can I ask you something, Ms. West? Why can I not get a bond?
Because you're on 2 felony probations and the allegation is that you committed another felony offense.
I don't think there was a crime, taking some tires, getting some tires out of the
Well,
dumpster.
then that's a bigger problem. All right, you can go back with the bailiff.
I don't see that you filed to have him examined.
She said she got it this morning.
All right, let's bounce back over to Judge Boyd in our attempt to have 9 to 11% more of her.
All right, the court is calling 2024 CR 6514, State versus Rubin Ibarra Solano Jr. Can I have parties announced?
Megan Galloway for the state. Alma Benavides for Mr. Solano.
And are you Mr. Solano?
Yes, Your Honor.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney and the first amended motion to revoke community supervision with your attorney?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Are you the same Ruben Ibarra Solano Jr. who's placed on community supervision in 2024 CR 6514 for the offense of possession of controlled substance penalty group 1 less than 1 gram on July 30th, 2024 for a term of 3 years? Is that you? State?
Violation of condition number 4 in Bear County, Texas. The defendant Ruben Ibarra Solano Jr. did then and there fail to report to the supervision officer as directed on 4/7/25 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And
Yes.
we waive and abandon the remainders.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4? The court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility
Yes, Your Honor.
and up to a $2,000 fine. Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it is for the court to grant the state's motion, revoke the defendant's community supervision, sentence him to 8 months in the state jail, and the state would be taking into consideration clause number 2025 PF 24487.
All right, and what is that offense?
It is a possession controlled substance PG1 less than 1.
All right. Is that the agreement?
It is,
counsel?
Your Honor.
It is, and we would also ask the court to consider giving him credit for the time that he was at ISF from October 30th of 2024 through March 3rd of 2024.
And did he successfully complete ISF?
Yes, yes, Your Honor. Yes, sir. 4 months.
Probation, was it successfully completed?
I believe it was, but I just want to make sure. Yes, sir.
All right, are you asking the court to follow this agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
I'm Ruben Ibarra Solano Jr.
Why were you not successful in probation?
I lost my dad in December of 2024, right before Christmas time or whatever.
All right, so this is in April.
That's right. And my mother got sick on me in March.
But this is, you were on probation July 30th, 2024. That's when your probation started.
Yes.
And so your answer to, I lost my father, my mom is sick, let me not be there for them, let me go do drugs. That was your answer.
I was hurt. I was hurt. I just lost my dad. My mother got sick right behind it.
Yeah, so your answer was, let me go use drugs because that will definitely help the situation. You made choices. And either you are going to stop using drugs or you're going to either you're going to end up dead or you're going to end up in prison. That's the only two things that are going to end up happening. And your go-to when something traumatic is happening in your life can't be, let me go use drugs. You're using drugs, didn't help the people who were suffering because you lost your mom. You're using drugs, didn't help your father who was ill. Now, is your father still alive?
That was reversed.
Reverse. Is your mother still alive? All right, so your mom is still alive and you're not helping her because you're about to go into custody, into an institution in due time. And when you still get out, you're going to come back out and you're going to use again. And then you're going to put that at your mom's doorstep. And how old are you?
44.
You're 44 and your mom's going to have to support you because you're not going to be able to get employment. And your mom is probably going to let you come live with her because you're her baby. You're her mijo. Did I say that right?
Yes.
It's going to be, oh, my mijo, right? And you're going to come stay with her. You're not going to work. You're going to use drugs. You're going to look her in the eye. You're going to be dishonest with her and say, I'm going to do better. I'm not going to use again. Then she's going to expect that you're using and going to suspect that you're using. And you're going to look her in the eye and you're going to tell her a story that's so believable. And she's going to want to believe it because you're her mijo. And then she's going to wake up one morning and you're going to have stolen from her because you're going to have to support her habit. So either you're going to change or you're not going to change. But if you choose not to change, don't put that on your mom's doorstep. Be the best person that you can be by writing her a letter and say, hey, Mom, I got this great job. I'm working in the oil fields. I'll be able to visit you whenever I can. And then that way she'll think her mijo is doing excellent in the oil fields and she won't have to see you lose your way. You understand? All right. The court is going to grant the motion, sentence you to 8 months in the state jail facility. Taking consideration 2025 PF 24487. There's a $2,000 fine. The court will give you credit for any time served and credit for any time served for successful inpatient treatment. And let me just tell you, the reason why I'm giving you credit for the time you serve inpatient is because legally I must. If legally I didn't have to, I wouldn't give it to you because it appears that you didn't learn anything. You understand?
Yes, sir.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And I'll suggest the therapeutic community as well. You'll have to request it, and they will either put you in the program or not, but it's to help you with any drug issues you may have. Do you understand?
Yes, sir.
All right. When you're released, if you can't find a place to stay or transition with your sobriety, if I'm still here, you come back here, I'll make sure you find a place for you.
There's a place called Christian Ministry. I'm gonna go to that place too.
All right. So here's the thing. You're saying good things right now. You need to hold on to that. And again, write that letter to your grandmother, or to your mom, and tell her, I got my life together. I'm going to be working in the oil fields, and I will see you as soon as I can. Write her that letter. And then when you're clean and sober, drop in to see her so that she can see you and know that you're doing okay. And then say, I'm going back off to the oil fields. And once you have a track record of being sober, then maybe you can see her more often. You understand? All right, good luck to you.
Thank you, Judge.
Thank you. Have a good one. Yes.
So a little off docket humor for a second. The whole mijo thing reminded me. We used to do a lot of consulting type of work, and about 15 years ago, we held a contract for a little while to do pricing audits at various places. And in the center of Phoenix, there is a Fry's Mercado. Fry's is our local Kroger variant, and the Mercado still is a market that has all the traditional grocery stuff, but then a lot of stuff that you would want if you were more Mexican leaning. So a much more expanded meat counter with fresh stuff there, expanded produce, things like that. So I'm in there on a Saturday morning working on this audit, and all of the young parents are in there with all of their children, and the majority of them are Spanish speakers. And as I'm working in the aisles, all I'm hearing is "mijo, no, mijo, no, mijo, no," as these kids are misbehaving and their moms are getting on them. So henceforth and forevermore, and to this day, we go to that market a couple of times a year to pick stuff up, because we like to make a lot of our own things that need a lot of fresh produce that I don't necessarily grow here myself. But to this day, we refer to that market as Mijo No. That's its official name. Just thought I would share. Let's check on our bear friend. Still out there fishing. Good for him or her. It's hard to tell. Let's go back to Louisiana. Get your votes in.
You're on mute. Please unmute it if you would. Is anybody in the room with you that can unmute that? Why don't you get somebody? Is there anybody standing around outside? We can't. Just unmute. Okay. All right. Now, what is your name, sir?
My name is Devin Coulter.
Okay, Mr. Coulter. And you are at Orleans Justice Center, is that correct?
Yes, sir.
Okay, is anybody from Orleans Justice Center in the room with you?
Yes, sir.
Would they introduce themselves, please?
Deputy Porter.
Okay, thank you, Deputy, for hosting us today. We appreciate that very much. Mr. Coulter, my name is Steve Prater, and I'm going to be asking some questions today of you, along with my board members, Mr. Chuck Tillis and Carolyn Stapleton on my left and right. Okay, and we're going to be trying to get to the bottom of why you're in jail for this revocation and deciding whether you should stay or not. Do you have a revocation waiver in front of you?
Yes, sir.
Okay, would you hold that? Okay, is that your signature at the bottom?
Yes, sir.
Okay, all right, you can put it down now. Thank you. Just wanted to make sure you had it and that you understood it and that you had signed it. Mr. Coulter, you're charged with 2 violations, 2 rules. When you get out of jail, you sign this deal saying you won't violate these rules. One of them has to do with criminal conduct, and then one has to do with paying your fees back. So let's talk about the fees. It says that you owe $126, and that's way less than we usually hear. So do you owe $126?
Yes, sir. Yes, sir.
Okay, so you're gonna plead guilty to that, and we'll find you guilty of that since you admitted to it. Well, let's move on to the serious one. The serious one is number 4, and it's a domestic abuse battery resulted in an arrest from 3/30 of 2025 while you were at Children's Hospital. You were there with a lady friend of yours, and the lady friend had a child that was there being seen by the doctor. Is that correct?
Yes, sir.
Okay. Did you grab her around the neck at the hospital?
Sir, I never put my hands on her, sir.
Okay.
I never
And
touched any type of way.
all right, I've got all the copies of the texts that you sent her, and I was concerned because I was hoping you didn't. I was hoping you didn't choke her or something like that. But when I look at the text, I'm troubled by it. And we'll get into that in just a minute. But there's 2 people that want to talk, I think, on your behalf. One is Kaylin Gross, or Grosse, and the other is Terry Pierce. Well, they're both with New Orleans Public Defender's Office. And since there's 2 of you from the same place, who wants to go first? And would you keep it brief because, you both represent the same organization?
Yes, sir, I can go first. And just to clarify, I represent him in the capacity of an attorney. And then Mr. Pierce is the client advocate that has been on Mr. Coulter's defense team and assisting with his case. But I can proceed if you're ready to hear.
Please.
Yes, sir. So thank you all for your time and good morning. Again, my name is Kaylin Gross. I'm an attorney with the Orleans Public Defender's Office. And we're asking today for you to not revoke Mr. Coulter, for you to release him back on parole with a condition that he participate in some sort of programming that my office can assist him in getting connected to. I've been able to get to know Mr. Coulter over the course of 4 months, and I see someone who loves his family, his daughter very much, someone who has a lot of ideas and potential, wanting to start businesses, wanting to go back to school, and someone who has already demonstrated that they have the capacity to work hard. While at the Orleans Justice Center, the first go around, Mr. Coulter actually attended and graduated from the Travis Hill High School, and he still keeps in touch with his mentor and teacher, Mr. Pittman, to this day. But, I know you mentioned the text messages, and while I see all those good things, I also see someone who has a lot of room to grow as a person and a lot of things to learn when it comes to processing emotions in a healthy, mature way. No one here contests that the texts between him and his former partner were unacceptable. They were unkind, and that is just not how you speak to a person. But as Mr. Coulter stated, we strongly contest that anything physical happened between him and the complainant in this matter. This case ultimately did not go to trial. It was not accepted by the prosecutor. Had it gone to trial, I would have a lot of questions regarding the veracity of the allegations. I would ask why there were no injuries observed at the scene by the neutral officers. I would ask why an injury was reported almost a month later having to do with the complainant's nose, while the allegations were that her neck was touched at some point. And I would ask that if this case were truly as straightforward as the complainant makes it out to be, if there was security footage, if there were witnesses, a security guard, if there were injuries, if there was a complainant that wanted it to move forward, then why didn't the prosecutor easily pick this case up and take it to trial? I think they didn't, because that evidence doesn't exist, because Mr. Coulter is not guilty of those allegations. But again, we agree that Mr. Coulter has a lot he can learn when it comes to processing emotion in a healthy way. And the next time around, not responding in the manner that he did, which is why he ended up in the place that he is in. I know that he recognizes that himself, and I think that's where my office can come in, and Mr. Pierce can speak more to the programs that we can connect him with, something that will assist him in coaching him to help develop more mature tools to process his emotions. And we can continue communicating with him and providing case management, even when his legal matter concludes. That is the capabilities of my office. So again, I would submit to you all that the solution here is not revocation. It's to allow Mr. Coulter to fully own his mistakes, to allow him to grow from it, and to allow him to continue to grow as a person and contribute positively to our community.
Okay, thank you. Thank you. Let's move on then to Mr. Terry Pierce. Mr. Pierce, would you talk to us, please, sir?
Good morning. Thank you all for allowing me to speak in support of Mr. Coulter. Mr. Coulter is a very young man. Mr. Coulter is one who, yes, we all sometimes at that age have certain issues in controlling our emotions. But I think sending Mr. Coulter back to prison will not kind of help him control his emotions. I mean, prison is not the alternative for helping him control that. I mean, we have programs like the New Beginning Behavior and Family Services that is located right here in this building, where I can actually stay hands-on monitoring Mr. Coulter's activities and really help him out. I mean, I think, and also he'll be able to get employment somewhere to pay off these fees that he owed and continue to pay these fees. Mr. Coulter is just a young man that actually needs guidance. He is not going to receive the assistance that we are willing to help him with and provide him with out here that in prison. Prison does not have the capacity to cope with individuality hands-on assistance. And these programs like Crescent Care, Genesis Behavior and Health Services, all of these are intense outpatient programs where they can help him control his anger management. And even if he had a substance problem, they would also help with that. They are professionals working in New Beginnings, like qualified psychiatrists, registered nurses, and social workers, counselors, and other staff members. And I would also, stay in touch with Mr. Coulter and help him. A lot of these guys did not have the guidance of a father figure. And I also had these problems. I had no one in my life when I was a young man to help guide me in the right direction. Mr. Coulter is not one of those individuals out here committing crime after crime and, that warrants being placed in prison. Just all we are asking is that you all give him an opportunity, just this one chance to see. And I will, like I said, help him as much as possible.
Okay.
Thank you.
Thank you, sir. We appreciate your remarks. We'll consider both of y'all's, what y'all had to say. And thank you for taking the time to be with us this morning. Okay,
Thank
Mr. Coulter, let me ask you just a couple more questions. We were talking about text messages. I mean, that's kind of sick. What I read, and I can hardly understand them with all the cussing and all the other in the text messages, but that's kind of sick. What you accused her of while the doctor's looking at her child, you're accusing her of looking at the doctor's private part. Where'd that come from?
Excuse me, sir. It wasn't exactly like that. Like we had an altercation earlier that day, and the whole day she just been kind of doing stuff that I've been seeing her like doing in negative ways. And I just addressed her about the situation, and I told her that I'm seeing what you're doing and I don't like what you're doing. And she just kept going on. So I told her I was leaving. Once I told her that I was leaving, that's when everything went downhill. You told me you gonna ruin me, you gonna make sure that I lose everything. And it was just a whole lot of stuff going on in that situation. But far as with the text messages, I do own up to that. I was kind of emotional at the time, and I did text her some things that I didn't mean, most of the text messages, and some of the things I did mean at the time because I was emotional. But I do love her, and I did live with her this whole time. Like, I was living with her. Like, she said that I've been doing these things to her, like, and I've been living with you the whole time. So why you ain't been called the police on me? Or why haven't you, like, you a teacher, you was teaching. So why, like, if I've been putting my hands on you or hurting you or anything, you go to work every day. Somebody would have seen that. Like, it's physical marks, anything would have been seen that day. And also, the doctor asked her, do you want to be seen that day? She refused treatment. So later on down the line, by me already in jail, you go to the hospital and something's broken on you. Like, why you ain't been seen the day of the incident? Like, it's been a whole lot of things going on in this situation with me and her, and I've been trying to get out of it. And I've been telling my mom, and I told my my parole officer came to the house multiple times to see me there, and she never told my parole officer anything. And my parole officer seen her and seen me. So if she would have, like, obviously, like, she could have saw any marks or anything on her, or my girlfriend could have told her, my parole officer, if I was violent towards her and uh hurting her or doing anything in any type of manner to her. Really, all this is about we getting into it that day, and I'm telling her I'm about to leave her. So all this started with that. Like, it got to a point where she was taking screenshots of my locations, trying to see where I'm going, and it was a lot of trust issues in this relationship. And I saw it was going downhill, and I tried to leave and get out of the situation. Also, like, at the hospital, it had cameras. Also, it had the security guard right there when we was fussing and I left out the hospital. I never put my hands on her, and the security guard told the police, the detective, that she didn't see me put my hands on her, and um that it had camera footage showing that I didn't put my hands on her. So
Okay, they don't have the camera footage. Okay, there's no footage. It wasn't available. Okay, so it's not like the camera showed you didn't do it. The camera didn't show you did do it. The camera footage is just not there. And the security guard was not there at the time. So those questions, I understand those sound good for you, but they really don't mean much to us because
I could say something like, really, like in my defense, it had a security guard there when I was being detained, when I was being arrested. It had a security guard there telling the police officer that I didn't put my hands on the lady, and also she was telling them that they looked at the camera footage and they didn't see me putting my hands on them, on
okay.
her.
All right, and so you went to jail that day. That was on March the 30th, I think.
Yes,
Correct?
sir. Yes,
Okay.
sir.
And then she didn't, I understand what your attorney said. She didn't go to the hospital until 4/11, which is some 12 days later with a broken nose.
Right.
And officer at the time, I understand the officer at the time didn't even note that there was, surely she would have been bleeding or something.
Right.
So I understand the problem because I had that noted in what I had found. If you were in jail for 12 days, surely her nose, I don't know.
We went into executive session.
Sure. We got a motion to go into executive session, which means we're going to talk about some sort of rule. And so all in favor of executive session?
Second. Yes.
We got a motion and a second to go into executive session.
Sims.
Yes.
Prater.
Yes.
State. Yes.
Okay, we're in executive session. We'll be back in just a minute.
Okay.
Okay, while they are in executive session, we can watch our bear. Bear is on about fish number 6 by my count, and it's raining now, so enjoy that for a minute. Is Mrs. TCF feeling better? Thanks for asking, Bailey, but not really. We're still in a bit of a struggle mode. So hang tight, and we'll go back to Louisiana once they're past their little powwow. And they're back.
Since I'm the one that's in charge of your particular case, my vote is to let you not be revoked. Okay. I want you to go with these folks and I want you to take anger management, domestic abuse, prevention, or some sort of domestic cases. I want them to monitor what you do very closely. I want you to stay off that damn phone. Okay.
Okay.
That is so, it's so unnecessary. And if you'll read back through those, the texts are so trashy.
Yeah.
You ought to think better of yourself than that. And I think you do. I think you can. I think these folks that I'm looking to from New Orleans, I think they can help you be a better person and a little more class than the text show. I'm troubled by the lady going 12 days later, contending that you broke her nose and there was no sign that evening. So for those reasons and with those stipulations, if it's okay with the New Orleans board down there, my vote is that you not be revoked. You also, do you ever see the lady that's accusing you of this stuff? You her on the phone?
I haven't talked to her since I've been in jail, and I had my family, my mom, contact her just because my clothes is over there. So what I do when I go home, I just get my mom or somebody else to go with me with the police to get my stuff and just get escort.
The other stipulation that I would put on you, on my vote, would be that you do not see that lady again.
Okay,
Contact with her, you send somebody else over there, don't you even go over there to get her stuff. It's like a very serious protective order,
okay,
okay? We're telling you, don't even go over there. If you see her in a store or something, you turn and walk the other way. And
okay.
stay off the phone and do what these folks from New Orleans say. That's my vote. Mr. Timmons?
My vote is do not revoke and with stipulations of no contact with this young lady and get anger management classes and domestic abuse.
Okay. Yes,
Uh,
sir.
Yes, and I agree with that. And tell me again, what is the name of the program that y'all want to go to? Second.
It's through the New Orleans Public Defender's Office, isn't it?
Mhm. Does it have a name or just say New Orleans Public Defender's Office?
It's Orleans Public Defender's Office. We're gonna enroll him in the New Beginning Behavior and Family Services Program right here in this building we're in.
Okay, thank you.
All right. All right, well, that'll conclude this hearing at 9:45 in the morning. Thank you.
Approved?
Well, go figure, my friends. An approval or a not revocation, or however you want to phrase it. Let's go back to Judge Boyd.
So it shows that Andrew Del Corto is on this?
That's correct, Your Honor. We are co-counsel. Mr. Del Cueto is actually on vacation until later this week, but we're co-counsel, so I'm appearing for him today.
All right, so do you have all discovery?
We do not, Your Honor.
What is missing?
According to the state, they've just uploaded, is that today?
Well, so if I can step in to help out this, so back in March 6th of this year, in Judge Nahara's courtroom, there was a motion to amend bond conditions that was heard. So it wasn't, Cindy was not the court reporter, it was the court reporter in that court. We've been trying to get the transcript from that court reporter from that hearing so that we can get and provide the defense, because that's obviously going to contain potential Brady.
Wait a minute, I'm sorry, what? You're whispering, I can't hear you.
I'm sorry. We've been trying to get the transcript from the court reporter in that court from that hearing so that we can have it provided to defense, because that is going to contain potential Brady and impeachment evidence for them. The last time that Ms. Jones, who's handling the case, talked with her, I believe was yesterday, she said she needed another 7 to 10 days potentially to get that over to us. So that's one piece of discovery that we need to disclose to defense. And as soon as we get it, we will do so. Additionally, this past Friday, we had just interviewed the victim, and I believe those notes were just uploaded for defense to view, or no, they weren't. Okay, so those do need to be uploaded. So those two pieces of discovery are outstanding still.
So it's just transcripts?
A transcript that we're trying to get from the court reporter, yes, and then the notes, that'll be a quick thing we can probably get done, but it's just mainly the transcript that's taking longest.
And who was the court reporter?
That I do not know her name. I just know that she was in Judge Nahara's courtroom on March the 6th of this year. That was.
So when were the transcripts requested?
I believe it was requested. I'm trying to see her notes. I don't have a specific date. I apologize, Your Honor. I'm kind of stepping out on this one.
I think it requested some time ago, closer to the hearing, Judge.
So how long was this hearing?
It was quite a long hearing. We were there all afternoon.
So just one day?
Yes.
So I don't understand why the transcripts are not ready.
I don't understand either.
Do you know who, I don't know who the reporter was, so. The police.
My understanding is the meeting on Friday has produced some significant Brady issues.
Just 1 second, one thing at a time.
I was just informed it's a Mary Berry is the court reporter. And today it looks like another request was sent out by Ms. Jones for those to get the transcripts.
Was she there in person?
I believe so, yes.
she's retired or she's freelancing now, so. That's what.
All right, so who has information on Mary Berry?
Yeah, this isn't the first request that has been sent out. Apparently, we sent one prior weeks ago and no response. It looks like it was sent to Angela originally, but found out that Mary was the actual court reporter that day, and Mary was on vacation at the time that request was sent.
I have her phone number. You want me to text her?
Yes, please.
Let me write the cost number and the dates of the hearing down and all that.
Yes. Okay. And then. You're welcome.
All right, so the first thing we have are transcripts from the March hearing, correct?
That's the first thing that's outstanding, yes, Your Honor.
Then what else is outstanding?
Your Honor, the state interviewed the complaining witness last week. And my understanding is that there is significant Brady issues that come from that. We have been informed that we are going to receive a notice or some sort of document with regards to that, and we still don't have that.
All right, anything else outstanding?
I don't believe so. I do know that on Mr. Del Cueto's side, he had requested from us as well to get any and all reports where the victim was, like in separate matters, a victim, an accused, or a witness from both SAPD and BCSO. Those have been received and have been uploaded.
All right, is there anything else other than these two items?
I do not believe so.
I think that's it, Chris.
All right. So this is coming back. It's coming back, Norma, the week of August 4th. So they should have everything, just put it on that August 7th, that Thursday. And if the transcripts are not ready, then she'll need to be here to let us know when the transcripts will be ready.
Yes, Your Honor.
August 7th. Anything else? All right, let me see what page he is on.
He's on page
1.
yes. Okay.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome. And Norma, you can put that down as fine.
All right, let's bounce back over to Judge West.
Court entered a pleas of true to counts 1, 2, and then 4 through 10 in motions to revoke probation, on probation for sexual assault of a child and indecency with a child. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. We have.
Are there any additions or corrections?
None I'm aware of, Judge.
All right, Mr. Parker, you may proceed. The agreement, there was no agreement, correct?
Correct.
It's unagreed. Okay, go ahead.
Just, Judge, from talking to him on the several times I've talked to him, everything relates to be a money issue. Well, I say everything, many of the things relate to being a money issue, not everything. Yes, it's, and money comes from job, and that's because of his charges. He says he hasn't been able to get a job, and which that doesn't surprise me, but he states that he has tried to get a job, but being that he does not have a job, he doesn't have any money, and he couldn't pay for the polygraph, he couldn't pay for the assessments, the substance abuse assessments, and the various other programs that he was ordered to do. You know, I understand he should have worked with the probation officer about, you know, what he could do to be more compliant, and he should have showed up for sure. And I think once you don't show up, you hear the same argument over and over, and you get scared. But that's basically what it boils down to for a lot of these violations. And he'd like to address the court about some of the other things, and has written something to the court that he wants to read to the court.
Okay, go ahead.
So much, I thank you for hearing me today. And basically, I just want to thank you formally for allowing me to receive probation in the first place. I was given a chance to re-enter society, not be sent to jail or prison time, to create a better opportunity for myself. And I also want to say I'm sorry for most importantly for the actions I made to be in front of you today. I should have made better choices and not to handle myself, so please forgive me for that. After the night when I received my stipulation and probation, I didn't fully know the situation.
Speak up.
Yes,
Speak slowly and speak up some.
Yes, ma'am. I have to admit, when I had received my stipulations on probation, I didn't fully know the situation or what to come with my charge, since it was all so new to me. Truthfully, it was overwhelming, something I was content about, leading to decisions that I made and now formally regret. Spending time in Jefferson County Correctional Facility, facing adversities, understanding I was given grace with probation, with the support system in place for my errors. Renewing my mind, I could have dealt with all differently. Seeing that I had multiple chances by you and my probation officers that I could have changed for to have a better future to create for myself, to crucify the old and make a path to the new. I understand that I need to make changes personally and mentally, and I'm dedicated to do that, and I thank you for your time.
What can you tell the judge to make her have any hope that you could, if you were kept on probation, that you would be able to complete it and do the things you're supposed to do? Can you tell her that?
I can say that basically I've learned from my errors. I know I spent time for like a minimum time in jail, and I can like get up, I can work, and I can get to it, because I just really want this chance to redeem myself and to really work and go for it.
All right.
I can do a better job, and I know it.
So.
And Judge, that's, and I mean, I don't think anybody could say anything better. He's admitted what he did. He knows what he did, and he realizes, and that's, you hear people say, I learned from sitting in jail, you know, I learned, but he pointed out, I realized the opportunity I've been given from this court, I realized the chances that the probation officers given me, and I think there's some consideration to be given to that. I think it's truthful. Not that
No, and I appreciate that, and I guess, so when you're talking about the opportunities that you've been given some opportunities that a lot of people don't get, because your case was sent to Harris County, and they actually paid for your treatment. And even though they were paying for the treatment, you were still unsuccessfully discharged. And so there were some things obviously that required you to pay for, but the fact that that was being paid for you and you still didn't complete it, that you continued to smoke weed because you were bored and felt like you needed it while you're on 2 probations for these serious offenses. Mr. Hoffpower?
Also, Judge, just I want you to note in the report that always his attitude has been discourteous, disinterested, and flippant is what they said. The courtesy officer also speaking to Ms. Martinez, who is the courtesy officer that keeps up with them from here. He's just refused to cooperate. He even went in knowingly to a novelty store looking for a job, knowing he cannot be anywhere near that, and actually wanted to get a job at a novelty store. When told that he shouldn't even be in there, he was flippant about that as well. He's not serious about it. He's got a flippant attitude. He is disconnected and unfazed. He's been multiply warned, and he has made no progress, indicating he will never had any intention of putting forth any effort. That's about the worst, review I can think of in regards to a person who was given courtesy supervision on 2 very serious charges and took none of those opportunities. Now, I understand what he says here now, but that in light of what's written on the page and what came from Harris County and through Ms. Martinez being here.
Ms. Martinez, do you have anything to add? Thank you for being here.
No, ma'am. I will say it was alarming. He didn't seem fazed at all, even at the potential of time that he was looking at. We had a judicial review, gave him some things to do. He did nothing. His mom paid his rent, so he had stated that he was selling his artwork. I don't know if that is true. If it is true, that would have been some money that he would have had, but the fact that treatment was free and he was going to group high and he didn't participate. He was more of a distraction, according to the counselor.
Can you say something on that?
Sure.
The mine does not seem unfazed. The reason why I think she said that is because I went in and I did the homework I was supposed to do. It's just that she said I was disorganized for the most part. I did my homework. I just needed to organize to see what placements need to be put in. And I never went there high. I went in, I did it. The only the problem she had was with me not fully having an order on my paperwork and all my homework that I needed to do, but I had all my paperwork completed, and I did speak with the group, and I did cooperate with the group also.
All right, anything else, Mr. Hoffpower? Anything else, Mr. Smith?
There you go.
Mr. Parker, nothing else? All right, so Mr. Anderson, you were right when you said that you got such a big opportunity when you were placed on these probations in the first place because of the nature of these offenses. And I can't, in good faith, look at all of the things that that you did or didn't do that you were supposed to and just say, okay, well, now that you've been in jail for a little bit, you understand and you're going to be okay. I'm not going to do that. In cause number 23, DCCR 0290, I'm going to find counts 1, 2, and counts 4 through 10 true, find sufficient evidence to find you guilty, and at this time find you guilty of indecency with a child. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 230288, also find those same counts true, find sufficient evidence to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. The fact that you received probation in the first place because the victims went along with that is the only reason you got it. And at this point, I can't continue to put anybody else at risk. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You need to sign that with Mr. Parker in a minute, and then he'll give you a copy. I've also handed you, hang on. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about those laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Parker. All right, y'all can sign that, and then he'll give you a copy. Thank you, Ms. Martinez.
So can I appeal this or what?
Talk to Mr. Parker about that, and he'll get it filed on your, if you'll give him the last two, or the last one, and you can take one, and if you'll get that filed for him, and then file a motion to withdraw, and then we'll get an attorney appointed for that. Dedrick Davis.
Here. Hey, don't take him. I mean, he'll still be there.
This is taking a lot longer than normal. You good over there?
I'm good, I'm fine, yes, thank you.
Let me know if you need a break. Sometimes I forget. All right, sir, are you Dedrick Davis? No. And Mr. Parker, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Davis, in cause number 24, DCCR 0344, I have a motion to revoke your community supervision. This shows that you were placed on probation May 14th of 2024 for the offense of theft of property with previous convictions, and that was a 2-year term in the state jail prison, and it was probated for 5 years. Is that correct? Answer out loud, yes or no. Thank you. It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department April 4th and April 14th of 2025. And is that true or not true? True or not true? Count 2 alleges that you failed to work at, count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? Count 3 alleges that you failed to enroll in services at the Spindletop Center as ordered. And is that true or not true?
That's true. We'll abandon, state will abandon count 4, no.
And 5 or not?
Not 5.
Okay. Count 5 alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily?
Yes,
And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Davis is not competent?
No.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, or your plea is of true, freely and voluntarily. Find that you're mentally competent. Find counts 1, 2, 3, and 5 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You were handed, and I talked to you about the firearm, not being able to possess a firearm when you first got your probation, right? I've given you another copy of that. Make sure you read it and you understand the rules with regard to not being able to possess a firearm. All right, good luck to you. You can go back with the bailiff. Alvin Lewis, Mr. Parker. These are both motions.
Yes, Judge.
Would y'all print one out for me, please?
Yeah.
Or both out for me?
Here.
No, I'm gonna, I need the original ones over here.
You good?
Thanks.
Judge, our agreement is before we consider it. It's for the ISF substance abuse track, that new offense, that marijuana has not ever been brought into.
Thank you. All right, are you Alvin Lewis? And will your client waive the formal reading of the motion in each case?
You will, Your Honor.
Which one are you doing?
3. I have both of them. Well, I can do the other one too.
I just clicked the other one. Don't worry about it. All right, so in cause number 19-32086, I have a motion to revoke your community supervision. Shows that you were placed on probation November 12th of 2019 for the third-degree felony offense of failure to register as a sex offender. That was a 10-year term that was probated for 10 years. Is that correct? And then in cause number 21-37343, I also have a motion to revoke, in this one, to revoke your unadjudicated probation. Shows that you were placed on probation June 21st of 2021 for the offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? Each of these motions allege that you violated your probation, and the state is going to abandon one, correct? Is that what you said?
No, Judge.
Oh, he was arrested for it. Okay.
Correct, I just wanted the court to know the case has not been brought to that.
Okay. Count 1 alleges that you were arrested for the offense of possession of drug paraphernalia on April 22nd of 2025, and is that true or not true?
True.
Count 2 in each case alleges that you possessed a drug, marijuana, on April 22nd, 2025, and is that true or not true? And then count 3 in each of your cases, or both of the cases, allege that you are behind in your court assessed fees, and is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probations, but order that you enter and successfully complete the substance abuse track of the ISF program. Is that your understanding? So with regard to that evading, I think we're less than a year out. And so I think with that program, I'm inclined, if I'm going to go along with this, to extend that for a year or so. Yeah, I mean, you're on 10 years for the other one anyway, but the evading, it was a 5-year probation. And I think based on what's been going on, I'm going to add a year to that, just so you can get through this program and the aftercare and all of that. Does that make sense?
Yes, ma'am.
Okay. You can ask a question.
How many years do I have left on the 10-year?
Look, you're asking me to do math after my morning?
Oh, I'm sorry. I'm sorry.
The rest of it.
Yeah, so if you were put on in 2019 and you had 10 years, so that's 2029 for that case, okay?
Yes, ma'am.
All right. Okay, so state tenders number 1 in each case?
No objection, Judge.
It's admitted in each case. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
All right, Mr. Lewis, in both of your cases, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probations, but I'm not going to do that. I'm going to follow the agreement that you made with the district attorney and continue your probation and order in each case that you enter and successfully complete the substance abuse track of the ISF program. In cause number 21-37343, I'm also going to extend that probation by 1 year as well. These were agreements. I'm going to hand you in each of your cases trial court certifications that shows you've waived any right to appeal. I hope you understand the opportunity that you're being given today. Take advantage of it. Do what you need to in ISF to get the tools so that you can be successful and not end up in prison. Because if you end up back here on another motion, that's very likely what will happen. All right, give me just a second. One of them's printing. I gotta get the other one. Yes, sir. Good luck to you. Mr. Parker can bring those back in just a second if you want. Let me get the other one printed.
What that was.
All right, the Almeida Miles, Mr. Parker. This is the last one for Mr. Parker.
All right, we're one up and one down. Let's go back to Louisiana and try to break the tie.
Is that correct?
This is West Baton Rouge.
Okay, and who are we speaking to?
I have I'm Deputy Myers. I have Mr. Burnside, Mr. Matthews, and
Okay,
Borman.
hold on just a second. Let us figure out what we.
And while they figure that out, let's go back to Judge West.
Ms. Miles, in cause number 24-2330, you're charged with the third-degree felony offense of tampering or fabricating with physical evidence from October 14th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 10-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Miles is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we will come back later for sentencing. Mr. Smith, what is the state's position with regard to bond reduction based on that plea agreement?
We're not opposed, Judge. There's no adult criminal history. There was some juvenile.
Is there, obviously, I would think there was some, is there anybody she needs to remain away from or not have contact?
Case or Nakia Brandon, Nakkeya. Mykesha Victoria, Mykkeisha.
Victoria?
And then Brent Martindale.
All right, so what I'm going to do, Ms. Miles, based on the nature of your plea agreement, is reduce your bond in your case to $1,000. There's going to be some very important things as a condition of that bond if you're able to make it. The first is that at least while we're pending sentencing, I am going to order that you wear a GPS monitoring device and remain in Jefferson County. Okay, so you'll have to pay for that device, probably just until sentencing, but we'll see what happens on that pre-sentence report. You're also, as a condition of that bond, ordered to have absolutely no contact, no communication with Nakia Brandon, Mykesha Victoria, and Brent Martindale. That obviously means in person, but it also means any other way, electronic means or DMs or Snapchats or sending messages through other people. If I find out while you're on bond that you do any of these things that you're not supposed to, talk to any of those or whatever it is, then your bond will be raised, obviously, but I don't have to accept this agreement and things could be much worse. Do you understand? Okay, you can go back with the bailiff. We'll see you at sentencing.
Oh, also, if you get out of jail, talk to the,
Yeah, also Miss Miles, if you make bond soon before probation talks to you at jail, the first thing you do when you get out is go straight to the probation department so they can start that pre-sentence report process. Okay? All right, we'll see you back at sentencing.
thank you, Judge.
Thank you.
Okay, back to Louisiana. They were so confused with what was going on in that one facility, they just totally moved on to somebody else. So let's see what happens.
To my right, we've all introduced ourselves around here because we've been going all morning. Time is 10:20 in the morning. The date is still the 22nd day of July 2025. We're here to talk to you about a parole request that you have filed. You're at Lafourche Parish Correctional Center, and we've already talked to the staff there, I think. Did the staff introduce themselves there again for purposes of this hearing?
They right to us, sir.
Good morning. My name is Asia Bro. I'm social services counselor for the facility, and I'll be speaking on behalf of Mr. Thomas today.
Okay, thank you very much. We appreciate that.
No problem.
Okay, Mr. Thomas.
Good morning. Good.
I didn't see you over there.
Over here. Good morning. Good morning. My name is Janine Wilson Boyd. I am the programming clerk for the Lafourche Parish Correctional Center. I will also be speaking on behalf of Mr. Thomas.
Okay, and y'all are the staff representing Lafourche Parish Correctional Center also, correct?
Yes, sir.
Okay, good. Excuse me, Mr. Thomas, the way that this is going to happen is we're going to give you a chance to tell us why you're there, what you were charged with, and why you feel like you should be paroled. And then we're going to hear from the institution as to how you have acted while you were there. And then we're going to go and talk to Elizabeth Martin and Sean Thomas Jr. and your girlfriend and your son. And then we'll be talking to the victim's sister in opposition. So to begin with, go ahead and tell me what your DOC number is.
564160, sir.
Okay, go ahead and start and tell us why you're there and what you've done to better yourself since you've been there.
Yes, sir, I will do. Well, unfortunately, sir, I was present when Henry Aldridge lost his life, and I didn't do or say anything about the situation. Basically, I failed to report this incident. I know that my actions were wrong because I should have said something, and I didn't, but I was scared for my life and my family's safety. I want to take this time to say that I'm truly sorry for the family and the loss and what they went through. But the circumstances were beyond my control, sir. But since I've been incarcerated, I'm a strong believer and actions speak louder than words. So not that I only wanted to come to the members of the board today to show the things that I've been doing, but I wanted to show that the things I've been doing to better myself, how I've been bettering myself, and the things that I've been doing to open up better doors for better opportunities for getting a job, if granted parole, to be there for my family, which is my children.
Okay. All right. And what courses have you taken there?
I had a paper right here, sir. I'm reading it to you, sir. So I'm about to read it off a paper to you. DOC reentry programs. I completed 100 hours pre-release, sir. I completed substance abuse treatment, enrolled in a STAT program. I completed phase 1. I completed phase 2. I completed phase 2, living in balance 1. I completed that. Phase 3, living in balance. I'm enrolled and set to complete on 8/3 of 2025. Continue reading this. medication. Right now I'm taking medication, assisted treatment, MAC education completed. Currently receiving MAC medication for treatment, education. I'm enrolled in high set, literacy, enrolled, achieved a level advancement. Well, I finally became certified for something in my life, sir. Forklift certification completed from technical college. I became a certified forklifter. A rigger, certified rigger, came from Fletcher Technical College, completed special programs and recognition. Like I had said that, I'm a strong, believe in action speak louder than words. So I've been doing tattoo removal on my face. I did one session already and completed session 2 scheduled. I became the highest set student of the month award on July 2025. And what it says? Goodwill, and I'm in class with Goodwill if I'm granted parole, so they can help me find a good job, sir.
All right. Well, thank you. Appreciate that. Now, could I have one of the persons from the institution there from Lafourche Parish Correctional Center that would be able to speak and tell us about him and his conduct since he's been there?
Yes, sir.
Okay, I'll speak for him. So again, my name is Asia Bro, social services counselor for the facility. So like Mr. Thomas highlighted, he has completed plenty of classes while he has been here. He has gone above and beyond the things that we have asked him, including completing DOC classes. I don't know if y'all could see the band-aids on his face, but he did start a tattoo removal session. He has one session down and then he has another one scheduled in the upcoming weeks. So that was very important for him to get meaningful employment, making sure that the tattoos in his past are not going to hold him back from a better future. That is sponsored through Goodwill, who is going to also help him to ensure meaningful employment once he is released from our custody. He has a well-established residence plan. He has a goal in mind of what he wants to do for employment. He will also be referred to our day reporting center upon his release, so that way he can continue to have further supportive services and then enroll in high set. While he didn't elaborate on a whole lot, he is enrolled in high set, and while maintaining a very full schedule, he still finds time to come in, spend extra time working on his high set, getting tutoring. But he is also enrolled in a literacy program and he is achieving level advancement through it. So not only is he trying to get his high set, he is also working on improving his reading, literacy, and comprehension. So, while he's here, we see him a lot. He has maintained positive attitude despite having a very heavy caseload. We have no disciplinary issues with him. He's been nothing but respectful. Like I said, I feel like he's gone above and beyond what we have asked of him to prepare himself for a successful release.
Okay. All right. Now we would, let's see, is there someone else from the institution there that wants to talk?
Yes, sir.
Good morning again. I am the programming clerk, and so I see Sean every day. I'm the first person he sees when he comes through that door. And one thing I can say is that I have never seen somebody that has been so respectful to others. And, a lot of people come here and just figure they just want to just get in class just to get out. He does not have that attitude. He goes above and beyond, just like my coworker says. If he needs help, he will ask you. He will be very respectful doing it. He comes in, hours and hours, to try to better himself. So he has really, I didn't know him beforehand, but just knowing him for the few months that he has been here, he is one of the best that I've dealt with.
Okay, thank you. Let's move on now to Elizabeth Martin, who is your girlfriend, according to the sheet. I don't know if it is or not. I'll let you decide that. but that's who it's listed as, okay? Elizabeth Martin, would you talk to us, please? Miss Martin? I think she's on Zoom somewhere.
All right. Okay, you can hear me?
Yes, ma'am.
Okay, good morning, members of the board. I would like to thank y'all for taking the time out on giving Sean a consideration for a parole hearing. We all understand that he should have reported it, and he takes full responsibility for not reporting it. But he was scared for his life and his kids and family safety, and then he wouldn't be here, be able to tell what happened today if he would have reported it. I see a big difference from when he first got incarcerated. He's trying to make it home to his kids that need him just as well as he needs them, because his kids' mom passed away since he's been incarcerated. So he has all my support on his journey, and I am asking the members of the board to give him a second chance so he can make it home to his kids that need him. Thank you.
Okay, thank you for talking to us. We appreciate that. Sean Thomas Jr., your son, Mr. Thomas, are you there?
Yes.
Yes, sir.
Tell us about your dad.
Look, well, I thank y'all for having him today. Hopefully, y'all granted parole, but
Thomas,
I feel like
hold on just a second. The Zoom camera that you're moving it around and
I'm sorry, sir. I'm sorry, sir. But yeah,
okay, thank you.
yes, sir. I feel like my pops deserve a second chance, to be out in the free world. I feel like he deserved it. Like, it's been improvement. And over the past 4.5 years, I feel like my pops, he a changed man. And and I just want him to be home. And I got these shirts. I got these shirts that we made. This is just a draft. But it's a little program we trying to put together. Like, if my dad do get granted parole, like for when he come home, this just gonna be for the youth. Like, basically like just giving them words of wisdom and just trying to talk to them. Just make sure they be in the right direction, stay on the right path and everything. So, and
Okay.
and really, I just want my pops to be home, and like, I just recently, had a daughter, and she in the NICU, and I just want to make sure, my pops, he be here to see her, like, he be able to be in her life. So,
can I ask a question? How old are you?
20.
20. Okay.
Okay, thank you, sir. We appreciate that. Now we'll move on to the opposition, Miss Lula Aldridge, who is the victim's sister. Would you talk to us, Miss Aldridge?
Yes, sir. I'm Henry's sister, and that's all fine and great what Sean has accomplished. And for the people who've known him for the jailers who've known him for a year. I don't know how long he's been in LaFourche Parish Jail, but Henry's going to be gone for the rest of my life, not the rest of his life. His life is over. And when Sean was going to court,
time out just a second. Are you by chance driving?
I am.
Well, that's not safe. We'll talk to you. Pull over somewhere and talk to us.
I'm over now.
Okay. All right. So continue what you tell us about Sean. You were proud of what he's accomplished.
Sure, because I mean, whoever's testifying for him, Sean's been on the street doing whatever he's been doing for years. Now he's been locked up for however you say for, but he's been at a correctional facility for a year that they know him. So the time his son is 20 years old, Henry, you want to see your grandkids. I want him to see his grandkids. I want him to see his sisters and brothers. He doesn't have that. We don't have that with Henry. You have a chance. Your child can actually go to the jailhouse and bring you the son, his child, to see. He can visit you. You made a choice not to go there, and even in court, we couldn't even find my brother. You knew all of this the whole time. You were in jail for 3 years, and you didn't come across until the last ending of it. So still change. You did what was necessary for you to move forward to get yourself free, to do whatever you were doing now. So at this point in my life, it's like,
Hey,
yes,
listen,
yes.
talk to us and
Okay.
not, hey, please, ma'am. That's
Yes.
part, okay?
Yes, yes. So my thing is, I don't understand how 1 year is going to tell you how this man is going to react for the rest of his life, because it's a year that he's been in LaFourche Parish Jail. It's been 3 years that they've been going to trial. He laughed the whole time at trial. It was a joke. So I mean, everything that I see is just an act to move on to the next level. Where's the sincerity?
Okay. All right, thank you for what you had to say about your sister. We appreciate that. Or excuse me. About the victim. Okay, Mr. Thomas. Now we are going to ask you some questions. Mr. Tillis, do you have any questions to ask?
Yeah. How long have you been incarcerated?
I've been incarcerated 4.5 years, sir.
4.5 years?
Yes, sir.
What was your, on a 20-year sentence?
Yes, sir. I was convicted of negligent homicide. Well, in the beginning, sir, I was charged with second-degree murder. I went to trial because I had to fight for my life, because the things that they were saying, they had somebody else on the charge too, and this person was convicted, which is the sister, Miss Lula. That's their second cousin. He was convicted for these charges. But I'm here today to take accountability because I was present, but I was convicted of negligent homicide. The reason I had got 20 years is because of my past, sir. They had gave me a bitch of offender. If it wasn't for that, sir, I would have been home already.
So the three of you all went and buried the victim?
No, sir. No, sir. I took a ride. All right. Henry, the deceased Henry. I knew him since I was a child. He was a great person. He raised me, just like Miss Lula did. They was always there for me. This family was a wonderful people. Him and his second cousin, which is Jamar Mosley. That's their family. They had got into it over some drugs, sir. They got into it with some drugs. And I'm the one, I can't really get into it between what the family got going on. So I tried to stop them from what they had going on. I really thought it was going to stop. I took a ride with them, sir. This became the worst ride of my life, sir, with these two individuals that was related to each other. They got into it again. They stopped the car. They got into it on some family property. A gun was drawn, and Henry was killed. Sir, if I would have got in between them two family members at that time, sir, I wouldn't even be here to even tell y'all this story today. And I'm so sorry I even took that ride, sir. I'm so sorry this happened to Henry, because he was a great person. This is my uncle. I call him uncle. And then I have a 13-year-old son in this family. His name is Deshaun Michael Thomas. The mother of my son, Henry Albrecht, is her uncle. Like, this hurt me. Like, I go through the same thing Miss Lula go through. I have to think about this every day, sir, of me even being present.
So after they killed him, you were there. Why didn't you report it?
Sir, I just was present, sir. All right. Yes, sir. Sir, I was just present when the second cousin killed his second cousin, sir. I was scared for my life. I thought this man was about to kill me too, sir.
I'm saying, but why didn't you report it afterward?
Sir, I really I didn't want nothing. I ain't want nothing to do with it, sir. I really didn't. And I'm truly sorry for not even going to say anything about it, sir. But this person was still on the loop, sir. I didn't want nothing to happen to my family, my responsibility, sir. But at trial, I'm sorry, sir. You about to say something?
No, go ahead.
At trial, sir, I even gave Miss Lula closure, Miss Lula closure of the things that had happened, sir. These circumstances were beyond my control, sir. I know right from wrong, sir, and I know my actions were wrong because I should have said something, sir. But I didn't want to die, sir. I ain't want nothing to happen to my family.
Okay, all right. I have no more questions.
Okay. Who buried the body?
Buried the body?
Yeah.
Ma'am,
There were shovels and the body was buried.
no, ma'am. It was nothing about no body being buried, ma'am.
Okay, here's what I'm reading. They left afterward and went back to the house. She stated that the three of them returned to the scene with shovels to hide the body. On November the 7th, 2020, the Terrebonne Parish Sheriff recovered skeletal human remains.
Ma'am, what happened?
Aldridge.
What happened there, ma'am? I was in the car. I'm the one that I'm sorry, ma'am. I'm the one that gave closure to the situation. I was in the car, ma'am, when this happened with these individuals. Ain't nobody was buried. I wasn't even convicted for second-degree murder or manslaughter, ma'am. I was just convicted for being present. What you say, sir?
So when you saw them kill him and y'all left the body there, you left with them?
Yeah, I left. I had to left, sir. I was in Gibson, Louisiana. I was in a car already. I just left and I never said anything. I was with them, sir. These two individuals.
You didn't go back with them. You weren't in the three that went to bury the body.
Oh no, sir. I ain't never gonna do nothing like that, sir.
Okay.
I was told about a day any of that right there, sir. And I know that's what the paperwork says, sir. But I wasn't convicted of none of them extra things, sir. I was convicted of negligence and homicide, and I understand that I didn't say anything, but so far as burying a body in it, sir, I never went back around that place ever.
Okay, thank you. Carolyn, you can finish.
That's it. I was just wondering what.
How long have you, the two ladies that are there at Lafourche Parish, how long have you been at Lafourche knowing them?
Oh, since I've been here, sir, I've been at Lafourche for 5 months, sir.
Okay. Is that the only, let me ask the ladies, so y'all have only known him for 5 months, is that correct?
Yes, sir.
Okay. All right. And when actually were you sentenced to 20 years?
I think in like October, sir. I just came to this facility, sir. I had just recently went to trial, sir.
So it's been October of 24. So less than a year ago, you were sentenced to 20 years.
Yes, sir.
Credit for time served, I'm sure.
Credit for time served? Yes, sir.
Did you get credit for time served?
Yes, sir.
Okay. All right. Okay. That's all. I think it's time to vote. Yeah.
Well, you got law enforcement opposition from Terrebonne, Homa, and the AG's office. You need to know that. There's law enforcement, and you got victim opposition.
What you say, Mom? What she said?
Said the Terrebonne Parish Sheriff's Office of Homa, Police Department are both strongly opposed to your early release, and the AG's office is opposed, and then you've got some victim opposition, as you know.
Yeah, no.
Okay, that's it.
Okay. Mr. Tillis, I think it's time to vote.
Yeah, my vote is to deny. And because there's not enough time served and law enforcement opposition.
Ms. Bateman?
I agree with Mr. Tillis and would add law enforcement and victim opposition.
Okay, and I concur. You've done great, and according to what the staff there says that you're doing great, so I want to give you some hope. I want to see you back in front of this board sooner rather than later. But we all agree from just hearing this that to have just gotten sentenced and to let you out less than a year after you got sentenced to 20, that just doesn't sound right, even though you've made such drastic improvements in your life. So continue that. I want to give you some hope. All right, keep going the direction you're going, but let's keep going that direction a little bit more under strict supervision while you're in the institution. So your request has been denied. The time is 10:44, end of this hearing.
All right.
Denied. To the surprise of no one, I suppose. I'm going to leave you today with the sea otter cam from the Vancouver Aquarium. They look like they're having fun there today. So I hope you all enjoyed the show today. I enjoyed being with you, as always. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Bailey, Ashley, and Michael, I'll see you a little later today, and I look forward to that. But go have yourselves a great day. Take care. God bless.